Pending item number 146, 106, my lord.
You mean analogous?
Analogous matter. Analogous matter. Land users case, analogous matter, my lord. Three matters.
Will all come on 12th. 12th land user matters. Land user matters are coming on 12th.
Permit me mention for correction of order. Correction of order, my lord. For correction of order.
What happened?
Lord, in the order, my lord, the charge memo dated was recorded as 15 June 2024 instead of 15 June 2023.
You mentioned Monday. Yes, call.
Item number 1. My lord, this is my application, my lord, for the Union of India. My lord, in this matter, the respondent was working as senior sectional engineer under CDO Tata from 11th July 2007 to 10th January 2021. My lord. My lord, he is retired from service on 10th January 2021 due to chronic nature of illness, which is uncurable. My lord. Now, my lord, in page 3 and 4, my lord, the VRS application was accepted and sanctioned by the competent authority, my lord. Then it was communicated to him on 7th January 2021. VRS sanction order physically handed over to him on 9th January 2021. VRS on, my lord, 7th January and handed over on 9th January. The respondent stated that although he has submitted the document showing handing over of railway materials to his reliever on 12th January 2021 and handed over the memo to the controlling officer on 13th January 2021. Well, he has said, my lord, no objection certificate or stores clearance certificate was handed over to him on 25th January 2021. That is 12 days delay. Well, he further complained that in spite of filing all documents within time, all retirement benefits were paid at a delayed date, my lord. Against this, my lord, he has filed an OA application, which is at page 21 of the P1, page 21.
He has been awarded interest on gratuity.
Yes, my lord.
What is wrong with it? You have taken 7 months.
No, my lord, he has respondent submitted application on 12th of October 2020, my lord, for VRS. That is 3 months notice, my lord. This was forwarded to the senior DPO, Chakrazarpur, for processing.
He has handed over on 9th January. You have taken 7 months. That history is not relevant. So what is wrong with the order? That is what we are asking. You challenge the order, unnecessary. You are for the,
I am for that.
nothing wrong with this. Yes.
Number two, I am for the so Mr. Ramkrishna Vishwas. There's the two supplementary affidavit annexing the original. It okay. My main contention of this petition is that initially your lordship knows that after the abolition of the Jamindari system,
After,
abolition of Jamindari system in the government introduced to collect tax Tahsildar peon. And to help the Tahsildar peon, another post was created for Tahsildar Mohra. My client, 1973, he was appointed as a Tahsildar Mohra. He worked up to 1984. But subsequently, as per the order of the Honorable Tribunal and in connection with a original application arising out of a WPST, in 2002, we are appointed as a Group D staff. And my client retired superannuated in 2017. My main grievance is that the authority, without considering my previous service, pension was given. I filed an original application before the
date of superannuation.
date of superannuation is 31 January 2017. Your Lordship will get it from the annexure P2, page 19. My Lord, I filed an original application before the Honorable Central State Administrative Tribunal, which was disposed of by the Honorable Member. My Lord, that Your Lordship will get it from the annexure, my Lord, P8, page 29. Your Lordship, kindly come to the page 29. Your Lordship got it, brother? But I am reading the second paragraph. The prayer of this application for a direction to take final decision regarding the full pensionary benefit to the applicant. The representation of the applicant was also considered and disposed of by the respondents in the Department of Land and Land Reforms Department on 9/3/2018. Well, Lordship, kindly pause here for a moment. But this order of 9/3/2018, no copy was served upon me. How the learned member of the tribunal came to a conclusion that this was caused. The said order of the applicant was communicated, but no communication was done. On oath, I have stated, no communication was stated that since his service was a temporary on basis and having worked for only 4 months, but not only 4 months. Since 1973 to 1984, I worked as a Procedural peon on the basis of a remuneration. Subsequently, my Lord, I was appointed as a Group D staff in 2002. Appointment upon erstwhile. Considering my erstwhile service. Appointment of my Lord, but if Your Lordship kindly see my appointment letter. But if Your Lordship kindly come to annexure P1, my appointment letter of Group D, page 18. May I read, my Lord? Sri Madhusudan Bhattacharya, that is my client, son of so-and-so, residing and so-and-so, and erstwhile Tahsildar Bohrar, he is hereby appointed as a Group D post. Therefore, my Lord, it was the continuation of the service. But without considering the past service, my Lord, my pension was allotted. And that is my grievance.
Page 30. Page 33.
Page 33, my Lord, Your Lordship, kindly come to.
Hold on. 33. 33.
My Lord, if Your Lordship kindly come to the page 33. Page 33. That is the order of the special officer, ex officio secretary, Board of Revenue. But kindly come to the paragraph 4, subparagraph below A. But I am reading, my Lord. The period of service rendered as Tahsildar peon must be continuous and followed without interruption. Therefore, my Lord, my humble submission before Your Lordship is this, that I am entitled to get the full pensionary benefit.
Counting the previous.
Counting the previous service.
But this is for Tahsil peon, this is not for the Morir.
But to help the Tahsildar peon, my client was appointed as a...
That you have already said, but this is for peon, this is not for Morir.
No, my Lord, no. But if Your Lordship... But if Your Lordship kindly come to my annexure P1, page 18. My Lord, got it, my Lord?
Yes, why?
And erstwhile Tahsildar Mohra, that is my client, is hereby appointed as Group D staff.
So the decision of July 95 that you have read, that is not for Morir, that is for peon.
No, I was always in 1973. I was appointed as a Tahsildar Mohra.
So therefore, this will not apply to you. This is for peon.
But as per my appointment letter, you also kindly consider this, you know. As per my appointment letter, is a erstwhile Tahsildar Bohrar is hereby appointed.
Why are you repeatedly?
That is my client Madhusudan Bhattacharya.
Why are you repeatedly saying that? That is what we are saying. You were what is Moharir, and this letter that you are referring to is for peon. This is not for Moharir.
But Your Lordship,
You
kindly
cannot
consider
write
my appointment letter.
What appointment letter? But appointment letter also says Moharir.
But I was in Mohra, Tahsildar Mohra.
So this will not apply to you. This page 33 does not apply to you. That is not for Moharir.
Very well, my Lord.
That is for
Very well, my
peon.
Lord. But if Your Lordship kindly come to my appointment letter,
That we have seen.
but I am entitled, my Lord.
That is clearly says
I am
the
entitled,
appointment
madam.
will be effected from the date of joining, and
My date of joining in
that
Group
date
D,
was, yes,
2002.
correct.
Previous service they counted in
It
this
does
page
not
33.
contemplate, does not have any provision contemplating any benefit of past service.
Yeah,
And
33.
it says if you agree to these conditions, you go and join. And after agreeing, you have joined.
Page 33
Therefore,
double
there is
nine.
no question.
Page 33 double nine.
না আপনি সার্টিফিকেট নিজস্ব বুঝে ওটা তো আর তহসিলদার পিওন এই সার্টিফিকেট নিজস্ব বলছে তাই তো এটা বলছে তহসিলদার পিওন এটা আমার আমি অ্যাপয়েন্টমেন্ট
Obviously, the work profile of the peon and moharir is different. Therefore, they have confined it to peon also only. Otherwise, they would have given it to moharir.
Madam, may I submit only one thing, madam? Madam, let them serve a copy. Lordship, kindly direct me
For what?
to serve the copy.
Or what?
Let them say that I am not
Hey,
entitled.
unless you
But-
convince
but-
the court that there is any
but-
occasion
but-
to proceed further, why should
But
they?
your Lordship kindly come to a conclusion that a learned tribunal came to a conclusion that the order was communicated. But I am still saying that
Taking it that it was not communicated. We take it that it was not communicated. How does that alter the situation? That does not. You still have to convince us
therefore
that,
my representation has not been considered.
but the tribunal has already decided the case. If they don't
The
consider,
tribunal has decided on the basis of that
See,
on 9 March order was communicated.
The tribunal can decide under two circumstances. One, when the representation is not decided, and the other, when the representation has decided. So either way, it has to decide. So that is of no relevance. You have to convince the court that this order was wrong or that you had any right for counting of that past
Was
service.
communicated. No.
We don't
Zero
find
purpose.
anything. Therefore, there's no
But
point. in it.
according to my humble submission before your Lordship, according to my appointment letter, I am entitled.
Alright,
That is my
that
submission.
you have said, yes.
That is also kindly consider that aspect also.
Prisoner has not been communicated to you.
And moreover, the order is back totally that it was communicated. But it's my specific affirmation that the order was
We'll
not
consider. Don't worry that whatever you have argued, we will consider.
communicated.
What is annexure F to the OA?
Annexure F.
F.
Annexure name, pardon me.
F.
F.
এর মানে কোনটা বলছে তাই তো
এটা
wait,
wait. But you also kindly wait.
So today you have filed a supplementary. In that also you have not annexed.
No, my lord. I have total OA was annexed, my lord. In fact.
Where is the annexure? Show us.
এটা কি টোটাল
হ্যাঁ
কই অ্যানেক্সার এফটা কোথায় কোথায় বার কর অ্যানেক্সার এফটা নেই তো Each কোথায়
You come to page 27 of your affidavit.
But
We have got it.
27.
yes. Counting of past service of Sri Madhusudan Bhattacharya ex UDC attached to SDLRO Durgapur under the DLLRO Purba Bardhaman. This is the subject of the
You said 9/3/18 was not served on you.
My lord,
You said 9/3/18 was not served on you.
yes, yes.
Come to the next page, page 28, annexure G of your OA. Yes, sir.
My lord, that's, এটা communicate হয়েছে তো, এটা জি তো, প্রমাণিত annexure। তাহলে এই যে 9/3/2018 from additional to Madhusudan. The undersigned, man, you also kindly bear me 1 minute. Undersigned is directed to refer the subject
This
above.
is the letter, sir. This is 9/3/18. You have filed it with the OA and you are saying it was never served on. Very unfortunate.
Like here also, my lord,
That's a different thing.
a wrong
That
conclusion
is a
that
different thing.
I worked only 4 months.
We are shocked at this, that you are saying it was not served when it is part of your OA. The
I'm
contents will
extremely
come
sorry. I'm
thereafter.
extremely sorry. I'm extremely sorry.
4 months is temporary.
My lord, here, my lord, anyway, 9/3 orderটা সার্ভিস হয়েছে তোমার, তুমি অ্যানেক্সিং করছো 9/3 order
In
service.
your OA, did you assail this rejection also? What is the prayer in the OA?
The rejection of way in tribunal.
9/3/18, did you challenge this communication of 9/3/18? You have just annexed it. Yes, you have challenged it. You are saying not served, very unique.
Impossible.
Well, here also, man, you also kindly allow me one. The undersigned is directed to refer the subject noted above and to say that in question of the past service counting in favor of him in the post of Tahsildar Mohra from 1973 to 1984 cannot be considered as he rendered his service in post for 4 months. Well, that is wrong, you know. That is wrong. I am not work only for 4 months. I worked since 1973 to 1984.
Correct. Yes, take down. Sorry, nothing can be heard learned counsel for the petitioner and the learned state counsel.
Yes. Oh. Yes, 30 Jan. And I am grateful. I am sorry for to say that.
Item number 3, I should be, yesterday, I should be very candid, the one coordinate bench, as your lordships was of the view on the last day that what is the wrong in the, so that all also been in that way also, this division bench hold. I am on, I should be candid, because that judgment is with me, there, I found that only thing is that, oh, these two. 2 copies. I have copies.
See, ultimately the
Well,
statute
that
will prevail.
only which my lord, kindly one thing which troubling me, this the judgment of learned trial judge, which only troubling me. Let your lordships just go through the judgment delivered by the division.
We were of the same view.
My lord, that only which troubling me, the judgment by the division bench, which has not been considered, the judgment of the single bench, only that aspect. I am trying to beseech it, my lord, that this paragraph, the judgment of single bench, your lordship, honorable single bench, that's paragraph 12. Which troubling me, the paragraph 12. Sorry, paragraph 12. In the memo. That this, the may I, this part. I direct the secretary to government of West Bengal to instruct each and every regional transport authorities covered under the above budget notification to publish a notice once in a month, the number of resultant vacancy, if any, within its jurisdiction with a cut-off date by which the date of applications for grant of resultant vacancy can be made by the interested parties. Matlab, this is not, matlab, the Acts does not contemplates that whether the authority has to publish a notification asking, inviting the applications for grant of a specific permit by declaring the vacancies. Matlab, this has not been contemplated either by the acts, matlab, statute, or by the rules. Matlab, that only, matlab, aspect, matlab, that has not been taken into, and my lord
The
is aware
provisions.
that
Let
is
us
not.
see them.
My lord. Matlab, this statute is section 80,
Huh?
section 80 of the acts.
Section 80, and there is one other provision also.
With the other provisions, there is no such provisions in the statute itself, whereby the transport
A
authority
single judge has considered just section 80.
and the 107 is the rule.
Therefore, we
My
are
lord, the
saying,
rule, my lord, the rule. Then I am placing, my lord, the rule 107.
first let us see section 80.
No, no, section 8. The
Let us go through.
subsection 1. Subsection 1, an application for a permit of any kind may be made at any time. So, the subsection 1. The Honorable Single Judge sought to be interpreted, the section 80 subsection 1 that
You have
which-
no right.
that too, only thing is that what?
The theme of the act is very clear. Considering the passenger convenience and road safety.
That, but the
The number of
thing is that
stage carriages are notified. It is not open-ended that anyone.
yes,
can apply.
there must
There is
be
no such a scope.
the 74,
Act.
yes. 74 3A is there, by which the notification has to be published, fixing the limit of the number of the vehicle. That I am not.
Very novel consideration.
That I am not. I am.
Therefore, you cannot claim that any time you will make an application and it has to be considered and you have to be granted.
No, that I am not. That I am not. I am not on that. The interpretation should to be that will be a lordship.
Para 12 has
Section
been
8
considered by the coordinate bench and we
section
find no
8
reason to differ with this.
Section 8 subsection 1.
Yes.
With great respect, subject to mileage corrections.
Section 8 subsection 1.
8010 subsection 1.
Yes, what does it say?
Thereby, these subsection 1.
That has to be that.
My understanding.
Understanding. Therefore, we are saying that.
That these at any time that will redundant in that
have
event.
to be read with section 76.
Section 76.
Yes, and
Well,
74.
74. I think.
Section
Right.
74.
Section 74 provides subsection 3.
That is
Section
not redundant.
74
That is
subsection
very-
3 I have gone through.
Nobody is stopping you from making an application.
And they have to reject my application summarily. That is the section 80 also.
Nobody
So
is
they have
saying-
not rejected. That is this.
That's not your case.
But that is they
Not your case.
did not reject my
That is
applications.
not your case. Come to the relief in your way. What have you filed the writ petition for? See, what is the relief?
Acceptance of the writ petition.
See the relief.
Applications. I have applications.
Say something which is not there on.
That I have gone through. The applications has to be made, but they are not accepting my application. That was our contention in the writ petition.
For the petitioner and the counsel for.
Item number 4, I appear for the petitioner. My lord, may I give just a brief context of the order? My lord, I am a lady. My daughter, while she was born with a grave cardiac problem. The short term is TAPVC. Well, I have studied and seen the prescription. It's called total anomalous pulmonary venous connection. So fundamentally, the connections from the pulmonary system, lungs to the hearts, it is completely incorrect. Now the maximum time is from the date of birth. Within 3 months, a complete open heart surgery is required to survive. Well, that is well known all over the world. Now, in case of my daughter, the surgery had to be done within 10 days. The features that, my lord, I come across is, now surgery was successful. She is now 3-year-old. She is surviving. But often she becomes blue because of that difficulty. So emergency treatment is required. Now, that is the context. The case I filed, I was transferred to Delhi. There is a transfer policy wherein,
You are working
as my lord, it was the transfer or promotion, senior accounts officer
in which office?
in principal of controller of defense accounts.
CDA.
Yes, CDA. Well, there are, I am working in one place. There are 17 other places. That's relevant. I may say little later. Now, in the transfer policy, Mala, there are 2-3 things which are favorable for the employees, coupled with for the employees who happen to be female. Those policies say, firstly, that on promotions in a domain of promotion, if I seek a particular station, if it is feasible to be accommodated, then I should be there in that station. Now, my lord, I lost to get any interim order solely on the ground that I cannot be accommodated. Now, the day this order was passed, what was 20th of January. And while this order was passed, the reliance was made on a number which was of December. That this is the number of sanction strength. More persons are there, therefore you cannot be accommodated. That seems to be the reason by the learned tribunal. What I find, my lord, on the 14th of January itself, that is post the order, 13 more persons have been brought in with the same designation of myself. So therefore, the policy which is favorable based on extent of feasibility, of course, that has to be based on fact. Well, that gets completely changed within 14 days. May I,
Been brought in where? The place where you
same place where I'm working and where I wanted to be there. But I can understand, because I can't afford to be completely unreasonable because I am suffering with my daughter. I can't be. I have to be reasonable. I'm aware of that. But at the same time, when there is a policy which, if I can use the word, my lord, makes
that is the development post rejection of your prayer for interim relief.
no. What I say is this, my lord, may I straightway show 3 things? May I just?
Just now said that after the interim relief was rejected,
Yes.
then these 14 persons were, or how many number of persons were brought
No.
in?
I said that the interim order was rejected on 20th. That's the 20th of January.
Yes.
The 13 persons were brought in on 14th of January.
At the place where you are working right
Yes. And the learned tribunal.
now. So feasibility has to be seen with effect with reference to the place that you want to be posted, or
No, feasibility in the context of what I want. I want to be in Kolkata.
you want to remain where you are.
Yes, they say that we could have accommodated you, but the fact remains X is the sanction strength. Now more persons are there.
Then now we have understood.
Now,
It's not arithmetic. These transfers are
no
chain
doubt, no doubt about it.
and they have a cascading effect. One affects the other, and the other affects the third. So exact numbers is not very relevant.
But may I say this? May I say this? I'm aware of that. It has a cascading effect, and if I search, I will find 90 judgments against me. But all my effort is this, that an exception has been carved out in their own policy itself.
Where is the policy? Let's see.
Yes. Lordship may straightway come to page 218, 8.6.
This is the policy you are relying upon.
Yes.
218.
Well, one thing I should clarify. This is the policy which was looked into, relied by the learned tribunal, and everyone made submission on that. Today in the morning, my lord, my learned friend apprised me there is a policy of 24. Fortunately, the policies clauses which were referred identical. I have checked that, so there is no difficulty.
They have not changed in the new.
No, no change. There might be some changes other places, but the clause I am referring,
The clause which you are relying upon.
no change, no change.
Remains the same.
Yes, yes,
218. Which
yes,
one?
218. 8.6. May I just say, care shall be taken to, may I, sorry, my lord, I should have started from the 8. It is at, sorry, 216. Exemption from transfer, deferment. The last paragraph at page 216. In case where an employee or member of his family is suffering from serious ailments such as cancer, polio, blindness, mental, psychiatric disorder, paralysis, etc., or is differently able, PCSDA and CSDS may at their discretion grant exemptions from transfer for specified limited period, provided the disease as certified by the authorized specialist and supported by medical documents papers. The case will be reviewed before. Now, Lordship may kindly come to feasibility 8.6 at page 218.
Please allow us to go through.
Ye-
Please, please allow us to go through.
Yes.
Give us 2 minutes.
Yes.
So your claim has been rejected
It has
by
been,
them.
yes,
Is there any rejection order?
yes, there's a rejection order at page 208. Lordship will find that my name is Shima Kumar, serial number 4. My original transfer was to New Delhi. Now they have made it to Prayagraj, Allahabad. So it remains the same thing as far as I am concerned for my daughter.
Where is your application
Yes.
which led to passing
Yes,
of this?
page
order?
79. Well, I specifically said that I would like to submit the following few lines regarding my request for retention. My lord, may I just add before placing the policy that I have referred a general some kind of protections for the employee. But there is, in addition to this, which is available to all the general employees, in case of promotion, there is something more. May I just show that and then come back?
This is a transfer on promotion.
It is a transfer of promotions. So for general transfer
From which post to which post?
from the post of assistant accounts officer
Yeah.
to senior accounts officer. Now, if my lord, if I can take your lordships to clause 9 of the policy at page 218. Because clause 9 was within the exclusive domain of promotion. 8.6 was to the extent feasible, and that is available to everyone, not for promotion itself. Choice stations, etc. I'm not saying, and the availability of vacancy. I say, my lord, there are on 9, there are two things. Availability of vacancy happens to be one of the considerations either to reject or to accept what I want on promotion. Availability of vacancy. If really there is no availability of vacancy, I may not be able to stretch under 9. If
Feasible does not mean number of vacancies.
true,
Feasible cannot be
it may
given such a
include
constrictive
correct.
meaning
True,
that it
true.
will, it only indicates the number of vacancies.
Correct.
And as it appears prima facie, we are just going through it.
Yes, yes.
That 9 cannot be read severed from 8.6.
Yes.
When it says choice in 9, it obviously refers to 8.6 also.
True.
So therefore, let us see the
True.
application.
May I just say, my lord, may I just read 8.6 once more? And the care shall be taken to post ladies attestation. So therefore, it's not available to everyone. Some exception.
That's clear.
Yes.
Yes.
Of their choice or at a convenient distance from the stations of present posting to the extent feasible. Well, I take the feasibility to be A to Z.
Yes.
And by saying A to Z, I say A could be the number of availability of vacancy, and there can be other points, definitely. Now, page 79, my lord, I specifically said about that. Lordship, may kindly visualize that a baby being born and open heart surgery within.
Trying to read that. Can we read that? Page 79.
Yes, I'm on exactly 79. On the severity, Lordship, may just look at the 10 days. Because just after birth, 10 days, and that's open heart surgery. Now, may I show the reason that learned tribunal did not interfere? Well, a third page, starting from the paragraph, corporatorizations of the erstwhile ordnance factories. Basically, 32 incumbents were posted at SAO against an authorized strength of 27. That seems to be the very fundamental. Sorry. Hmm. Hmm? Hmm. May I show your lordship the third page of the impugned order?
If we have seen it.
Yes.
Basically,
And in the light of, kindly straightway come to
we
page
are
2.
saying that there is a corporization.
Yes.
The vacancies have fallen in
Yes,
this
yes.
zone.
Correct.
Therefore, there is no scope
Correct.
for retaining her. The second thing they have said, she is relying on 8.6, whereas
True.
it is a case of 9.
True.
That is another ground.
True.
Third, they are saying we have already considered and brought her
So
closer.
therefore, there is a
Fourth, they are saying that place there are equal medical facilities.
true.
These are the
True.
4 grounds which
True.
has been accepted by the
Correct.
tribe.
Correct. These are, I can't say these are unreasonable, that one would be shocked after.
Has been accepted by
Yes.
the tribunal.
Yes.
Yes.
Now, to my understanding, the first reason being, this is the number of vacancy, more number are already working, so how can you be accommodated? So it's a very reasonable. To that, lordship may straightway come to 225. Before the third, just my lordship may kindly mark the date. Third page of the learned tribunal's order, the paragraph starting with corporatizations, 1, 2, 5th line, the date.
Yes.
As on 6th of December, as I said, December 24. Now, lordship kindly come to page 225.
You were relieved on 17th.
Yes. I was on childcare leave. That is also
You
something.
had gone on leave till.
But that was
24th,
cancelled. I was on leave even.
24th. But
Yes.
prior to lapse of the
Yes,
leave, they have
because
relieved
the
you on
moment
17th.
the moment they received the copy, usually in case of a childcare leave, that's my usually it's not cancelled, because it's childcare leave is unless something so shockingly required, childcare leave is never cancelled. So my instruction for my learned friends are that the very afternoon or evening they received it, the copy of the OA, they even cancelled. But in any case, lordship may kindly have a look at page 225. That would show that their fundamental
Page.
225. 225, my lord, that equals to 13 persons with an identical designation of senior accounts officer. They are brought in. So incoming 13. And the date was on 14th, page 225.
Yes.
Lordship, I have marked for an example, kindly the serial number 3. Just after the name SAO, that is the senior accounts officer. That is my designation. So serial number 5, thereafter 6, serial number 10, serial number 11. These way there are total 13. Serial number.
Is there any covering letter to this list?
Covering letter? 221. That is at 221. Transfer SOS. The competent authority on the basis of recommendations of the DAPB has approved the transfer order in respect of SOS on administrative ground. In fact, I don't mind this 13% be there, because my instruction is under this, my lord, this principal controller of defense accounts, in addition to the place where I am working, CGD, sorry. Oh, right.
And your transfer order is dated?
Well, that is.
The one where they have taken you to Prayagraj is dated?
Yes, Mala, that is date. Mala, that is
One.
I'm giving the date.
14/1.
14th of, yes.
And it says to join immediately.
Yes. And even my the childcare leave, that is also they give the reason at page 210 that the competent authority at this office has cancelled the CCL in respect of Srimati Shima Kumar with effect from 17th of January 25 due to administrative exigencies. And I have given page 63, part of the original applications, paragraph 6.8. I have given specific names of the persons also for who are there in this office. And I've said that, well, may I make my humble submission before Lordship is this. Being aware of the fact that I don't have a right, I am in a service, I have to be transferred. That awareness is very much there. Therefore, I can't afford to make a submissions which as if I have a right kind of thing. My respectful submission before your Lordship is this. It is a fact that my daughter had to go through an open heart surgery within 10 days. Well, that itself would indicate for non-doctors that
This is not in close proximity to that surgery also. This is more than 3.5 years later.
is my 3 years for a baby.
So therefore,
What happens, my lord, I had a conference, the client, they were there. What, because I wanted to know, my lord, I also want to screen that whether I can say that. Now, what they say that, well, sometimes she turns into blue. Now, that's not that every day it happens.
it's a very unfortunate circumstance.
True, it's a it's a very,
It is, if it had been your case that where she is now posted, there is no such facility or care available, then that would inure to your benefit. That's not your case.
no, I can't say that the Prayagraj is a place. I can't say that. I can't say, I do not know. Anyone might be able to get to know, no doubt about it, but I can't say that. My respect.
There are stations where
Yes.
they may not be having this
True,
level of
true,
care,
true.
then
true.
that would be a different circumstance.
But I was,
So therefore, this condition that she has, if it was a place, because you see, that's why we are going through this list. Just give us some.
yes.
This one, small body of the child. That is what such a small body of the this doctor said my infection child. Optional I don't know. Kolkata is not even like hometown. Who is like to family, party family.
Is in Jharkhand.
Jharkhand exists for their offices. But
The child's condition that you are seeking by virtue of being by
Etc.
There's a gender-based
Well,
benefit that you are seeking.
there are two things I am seeking. One is I am trying to, my lord, bank my case on the word etc. If Lordship kindly have a look at 8 Roman 1, that cancer, polio, blindness, mental, psychiatric disorder, paralysis, etc. Sorry. Okay. Okay. Yes. Okay.
you are referring,
Yes.
have you made them as a party?
No, I am referring two separate things. One is some number of persons who are there for long years. I have not made them as a party. And the other persons I am referring for the purpose, if Lordship kindly come to third page of the Learned Tribunal's order.
We
They-
understand what you are saying is that there were vacancies. If there were no vacancies, how 14 persons could have come?
But I'm trying to say this, that it's not that their point being, it's not possible because of the point X.
Give a further scrutiny to Annexure 2
Annex-
with the covering letter.
Well, I would, when it comes from your Lordship, I would.
Covering letter says the transfer is in two lists. There is an Annexure 1 to take effect immediately, and there is an Annexure 2 wherein the dates of the specific individual has been specified. If you don't move, one of them will be stuck up. All their dates are after your movement.
All their debts?
All their dates to this station are after your movement date.
Yes.
So it is not a case that there is sufficient space. Only if you leave, then one can come.
No, may I say this? May I say this? May I-
Let him please sit down. We will hear you. Don't worry.
Well, I am trying to say this, that the Learned Tribunal, based on the Learned Council for the respondents, decided, I would say it's a reasonably decided, that because the number of sanctioning strength is less, you cannot be accommodated.
Yes, you said that 14 persons are coming. Why can't I be
Yes,
kept
I say
there?
this, I say that,
But the moment you are kept there, one of these 14 persons will not be able to come. All their dates are joining are after your transfer order.
no, my lord,
So therefore, it is not a case that there are 14 vacancies available and still you are being,
no, all I'm saying is that,
there is no connection. You are trying to establish a connection.
yes, I'm trying
That
to,
there is a movement of 14 persons to the station where I want to stay.
yes,
If 14 persons can come in January, why can't I stay?
yes,
The
correct.
transfer order is issued in January, but their dates of joining vary from third week of January till March 25.
Yes.
So they all come in after the people move from here. Exactly what we had observed without going through the
Well, then
order.
that presupp,
Always that all these chain transfers have a cascading effect.
well, then
It's not arithmetic that if two can come, why can't
I
I?
understand. So in a larger perspective,
That is what the order is. You see the order.
Well,
See the dates,
well, may I see?
the various dates on which they have been asked to join in Annexure 2.
Well,
Just see serial 3, for example.
yes. Yes, well, serial 3, he has been asked to date of relieving is 13th of March 25. Correct.
Much after you will move. Likewise, serial 6, 29 January. Likewise, serial 10, 19th February.
No,
Only their movement, that is precisely what we were saying. It's not arithmetic.
But my lord, it is one, my lord,
Movement
it is
So
Lordship,
you must not be the only person moving from this station. There must be other persons moving from this station also.
may I just, total charge. Well, I understand there are 3 more others.
Three more.
And none of them have been released, but that is neither here, that is, I understand, that is nothing to do. Well, my humble submission before your lordship is only this, that after all, my lord, some kind of provisions are there, some kind of exception has been carved out. Despite,
Actually, we don't have to impress upon you because you have already expressed your conscious of the limited
but that,
area of
yes,
argument available to you. Had it not been for the medical condition, we would not have
true.
been
But
pondered for so long.
I'm completely aware of
But
that.
then,
Sometimes a little nudge of your lordships might, may I say this, nothing to do with the pure point of law. Their home happened to be in Jharkhand, but when their baby was saved by the Calcutta doctors, it is, I can't explain, put into words of any legal format, but all I'm trying to say, because it is my direct interactions in the conference
Her
that
husband is also in service.
no, he's in not in service. He's in business. Now it's like, because within 10 days there was the thinking of that baby cannot be saved. Now the baby is saved by the kind of doctors.
Half years ago, that's not something immediate. That is over.
No, that is over.
Ultimately, that
True,
is over.
true,
That was over
true,
more than 3.5
True,
years
true,
back.
true, true.
How long can that be a basis to say that I will not move from this station?
May I only request your lordships this?
And when your transfer is not to an station where there is no healthcare facility, it is, you don't say that.
No, that argument,
Your
I have not even a single word on that, because it's like a beggars cannot be choosers is kind of my situation.
If that was the situation, you could have asserted,
But,
and then they would be required to.
but that's not being the situations. I don't want to, I can't afford to say anything like that. My only humble submission, sometimes what happens, my lord, sometimes, I'm not saying that necessarily this is such case, that if there is a possibility, because sometimes it is the ego and the other factors that, yes, that happens.
That
I'm not arguing.
you're not impeded anyone as a person.
I'm not.
Place of malafide.
That
No such allegations.
I'm not.
Don't.
Well, I was because I also wanted to know, in the office that I'm working under this CDA, there are 16 more other offices also. Now this 14 I'm referring to the very same office where they brought in more 14%, but there are others also. Now
Said in the OA, we have seen.
yes, but a little
Big setup here, and there are more offices where you can. That you have seen.
Well, a little, sometimes a little nudge of your lordships might, if they consider. I'm not saying.
It is a promotion posting, and all these promotion postings are essentially based on urgency and whatever is the vacancy and requirement. My lord, the petitioner has considered, petitioner's representation was considered twice by the authorities, relevant authorities, and after considering all the relevant point, it has been decided to transfer her initial posting from Delhi to Prayagraj, my lord. And the Prayagraj pension office, my lord, has a requirement, and it deals with a lot of number of pensioners. There are more than 32 lakh pensioners which whose accounts are dealt in that office. My lord, firstly, the my lord, I am not being. I'm just referring to the notification. My lord, her representation was considered by the competent authority, and that is why she was transferred to such stations where adequate medical facilities available, readily available. So, firstly, she was transferred to Delhi, where there is no doubt about the medical facilities, and secondly, after reconsidering, the competent authority has decided to consider a posting which is nearer to her present posting, and that is available in Prayagraj, my lord, which also have ample medical facilities. My lord, it was considered under clause 8.
The tribunal has admitted the case, but refused to pass an interim order. So effectively, this will not have.
No, my lord.
There was a direction for. In the
Okay,
by,
file-
by the very same impugned order, they were asked to use an affidavit in opposition and reply.
And, my lord, the next date is on 17th March. So before that, we'll prefer a written statement over there. But yes, my lord, oral submissions. And the submissions remains the same, my lord, because it has been considered, my lord, and it is the promotion, since it's a senior grade posting and it's a grade A posting, that is why it is based on urgency and requirement, my lord. And the transferred policy, which my learned senior has been referred to, my lord, clause 8 of that policy, which is at page 216, it clearly reads that it is the discretion of the competent authority to decide on that factor, my lord, whether the exemption will be considered. As my lord had rightly pointed out, my lord, it has been 4 years after the surgery, and time has elapsed, my lord, and uh, so the consideration was taken, but posting was done as per the requirement, my lord. And also regarding the sanction posting PGTA of AA was accounting officers, there are a total sanction number of 43 posts, my lord, in PGTA Kolkata. And these 13 people, which is which my senior was learned senior was referring to, they will join after the relieving of the existing members, and my lord, if you can see, my lord,
You are
most of
saying
them,
things that we have observed. Say
yes,
something that-
right, you have observed, my lord, and 10 of them are coming from harsh posting, my lord. They are coming from Jammu.
We are asking you a very specific query. We want you to come back with instruction. We are just adjourning it, not today. Our application was considered under which clause? We don't require any reply. Just take an oral instruction. We'll pass whatever order we have to pass tomorrow. 2 weeks.
Item number 5.
supplementary affidavit. That was not with me. Malat, in spite of that, supplementary affidavit, your lordships have copy, but I have no copy. But here the impugn order, if your lordship kindly see, the impugn order passed by the tribunal, my lord, here is a specification that the advertisement made on the general category and the petitioner made application as per general category, as a candidate of general category. But specific case of the petitioner is that, my lord, there was no no mandatory reservation relating to physical handicapped person as per the Act 1995. If your lordship kindly see the advertisement made by the authority concerned, that is page 26.
Page 26.
Page 26 is the advertisement made by the authority.
Page 26 of
My lord, that is my application, WPST application. মানে that is মোট শূন্য পদের সংখ্যা is 42 and there was a reservation for তপশিলি উপজাতি অন্যান্য অনগ্রসর শ্রেণীর জন্য 7টি পদ সংরক্ষিত থাকবে, সাধারণ প্রার্থীর জন্য 23টি পদ, নিয়োগের ক্ষেত্রে 100 পয়েন্ট রোস্টার অনুসরণ করা হবে। মানে that point is taken that 100 পয়েন্ট রোস্টার অনুসরণ করা হবে।
why don't you give a translation, madam? Kind to the court. Be kind to us.
Yes, yes, yes. Well, this is true.
Cannot understand. You know that. Still you are
The
reading as
advertisement was published in 21st October 2011.
Yes.
Total 42 posts. And Malad,
What is the date of the advertisement?
21st October 2011.
11. Malad, that is the very top 26, Malad, in left hand side, 21st October 2011.
You know the script. Everything is in.
Malad, I filed writ application before this Honorable High Court within time. That was
What
dismissed.
within time you have filed
Malad,
much later,
2012.
much after, at least 6 months after your result was.
Malad,
declared.
I made
We have
representation.
gone through the facts. Don't say anything which is.
Malad,
correct
representation right to RTI application has been made.
What did
made-
you say in your RTI? Any question regarding reservation?
Malad, but in my
But
RTI application, Malad, they replied.
after 6,
Malad,
8
kindly see,
after 6-8 months, you realize
Malad,
there was
in
no
the year
reservation.
2017, they replied that
Okay.
100% roster will be applicable to all the government sector. Malad, that is kindly see, in the year 2017, they replied my RTI.
Now we are telling you that advertisement was issued in 2000.
2011,
You applied.
I
That
applied.
there was no reservation for you. You participated. You did not succeed. Then you made an application under RTI that please tell me what is the marks that I have got. Whether I appeared in these stages of exam or not. Nothing about reservation. Then you approached the writ court. And then you went before the CAT,
After
the state
obtaining leave,
administrator after
state
8 months.
admin.
And now you are developing a case that there was no reservation. Whether under such a circumstance, the tribunal was right in rejecting your claim or not, that is all we have.
My lord, tribunal, my lord, if your lordship kindly see the order passed by the tribunal, tribunal admitted that there was a lacuna, but at this
Who is
stage,
saying there is no lacuna? Who is saying? They are also not saying that there is no lacuna. Are they saying that there is no lacuna?
my lord, RTI application made within time and then
RTI is not regarding any issue of reservation. Please
Yes.
read all the queries in your RTI application. Show us that you have.
that is
written
page 36, my lord, there was a no point.
nothing. Suddenly, when they have sought some advice, then they have been told that, look, there is an infirmity in the advertisement, and then he has filed the.
But
And
tribunal,
in this way, the entire process should be scrapped. All those persons who are appointed, they should be rendered jobless.
my lord, tribunal,
In such a way.
my lord, 2012, my lord, I filed application.
Counsel for the petitioner.
This matter, my lord, I am for the petition, my lord. I have got the copy. I have used my reply.
Lordship, if your lordship has direction, I can submit. I can reaffirm it again. Yes, I don't have any problem because lordship, the question. You don't want me to give. You don't want me to give. Yes, yes.
My lord, only one thing, my lord, I will be praying today, my lord. I am praying for a few days accommodation. The question is, my lord, as to whether, lordship, I can remember, it's a medically decategorized there. He was seeking alternative appointment. No, my lord, I was in search of rules, my lord. I've got one, my lord. I'll be hoping, my lord, to get a few rules, my lord, supporting the case of the petitioner. My lord, next week.
Lordship,
Subject to, on 7th, my lord, subject to lordship.
Lordship, if you lordship kindly allow, I may submit the circular of railway board regarding abolition of the alternative appointment, upon which the learned tax has been denied. Yes. After third.
Number 7.
Monday, my lord, I had done this matter, my lord, if your lordship recollects, my lord. Yes, my lord. My lord, I have brought the letter because he's a very old person, around 80 plus, my lord. So I really don't want him to suffer for whatever reasons, my lord. My lord, there was one observation, my lord, since your lordship is basically a very relief-oriented judge, which I know, my lord. My lord, this application was suggested by someone, my lord, to be filed because of the fact that there was one liberty which was given, that with respect, while disposing the contempt, these cannot, that tenure, that is 77 or 97, this cannot be assessed by here, you file it before a different forum, even after the apex court order, because apex court, my lord, it was withdrawn with liberty to file the review. And in review, my lord, this is what came out, that this is a limited scope, so that is what it was. And based on that, my lord, yes, my lord, I leave it to your lordship, my lord. This is the letter which my junior has got it from the person. It's a handwritten. Let this be kept with the record, my lord. And lordship may this, however, should not affect whatever he is receiving, my lord. This is all I was beseeching. Well, today after this forum, I don't think I have any other forum, because why I say, my lord, because when this matter went up before apex court was in session, but there, my lord, the council, whoever was appearing, had prayed for withdrawal of that SLP with a liberty to file the review. In review, my lord, the court rightly held that the scope of contempt is very limited. So I cannot actually go beyond it. Whether it has been compliance or not, that is it. So I am giving you a liberty to go for the filing of a separate application before the approval. So they went and filed this OA. This OA, which is basically assailed before your lordship. But this is the... Yes, yes, my lord, I am showing your lordship. My notes are there. My lord, your lordship may kindly turn. This is the place from where, my lord, everything started. Because what fell from your lordship is absolutely correct. It was order dated page 98. Page 95, my lord, is the order of the review court of your lordship's brief. My lord, may I just read? It's a just 2-pager order. 4 paragraphs. My lord, 95 is start. The relevant portion starts from page 98. It's just a 2-page. Well, this application for review would arise out of an order in a contempt proceeding where the division bench recorded compliance of the order by the contemptor. The division bench also gave liberty to the applicant to proceed further, availing the remedy in law if they feel still aggrieved by the compliance. Hence, this application for review. Well, this is subsequent to the apex court's leave. Mr. Such and such, appearing in support of the application, would contend the authority, while extending the retirement benefit, did not take into consideration the decision. This was referred. He would draw our attention to the calculation sheet appearing at page 45 of the application to show that the period when the applicant was serving the railway as temporary employee was not taken into account. This question could be effectively gone into in a proper proceeding. The scope of examination in the contempt proceeding is too limited. We have already given liberty to approach the appropriate forum. The review application hence stands dismissed. This is what it was, which actually triggered the hope on the part of this litigant, my lord, to go and assail and actually try out that this is what it is. This is, my lord, that instead, because he is in service for 37 years, that would be there, and it was calculated as 19 years. Oh, yeta. But that is what he is saying, that I am basically being given from 1977. Yes, yes, yes. My lord, the OA is the, my lord, OA is starting, my lord, from page 30, and the relief, my lord, is enlisted from page 53, my lord. No, not 53, not 53. My lord, this is relief 8A, 53, internal page 19. Only that error to be taken into consideration. Pension sheet. Pension sheet. My lord, actually what I find, my lord, from this sheet, pension payment order, my lord, his date of appointment was 1st of October 1965. His date of retirement is, my lord, 31st of December 2004. Total service actually is, my lord, 39 years, 3 months. And it was actual computation for which this pension is being given is 19 years, 4 months. Net qualifying services, 19 years, 10 months, 24 days.
In WPCT number 175 or 2008, wherein there is no such direction.
My lord, I know. My lord, I cannot better the pleading. I cannot say anything extra. The thing is, my lord, I came at a very last phase in this matter. My lord, this is something I think I am in a very better hand. My lord, your lordship can give me the best thing. My lord, the reason is, my lord, this person is an octogenarian. And the thing is that, my lord, I had a talk. My lord, should have been. My lord, kindly sees, my lord, this matter is pending for such long. My lord, this actually shows the gravity, my lord, the opinion which was tendered, whatever was given. My lord, these all has culminated to this stand where we are standing today. I also personally felt very helpless, basically, when this thing came up, because whatever your lordship is saying, that it is as if that there has already been a specification by the higher court, you are supposed to just do the correction. More of a nature of 152. But that is not so. It is basically to check the pension record and to assess and ascertain. So that is something different.
Is an issue which was not considered, not decided.
Yes, absolutely.
But
I bow down.
View of the liberty.
The entire thing, my lord, the relief sought. I bow down, my lord. Whatever had fallen from your lordship, I counter checked and cross checked the papers, and absolutely I was ad idem with your lordship. The reason is, my lord, the language, the articulation is to such an effect that it is like, okay, the higher forum has already given you something, you are just to comply. It's more like binding the tribunal to do something based on something which has been passed by a higher forum. But actually, the fact is not so. It is only that the contempt has given a liberty. It has just liberated the thing. My lord, one thing I don't know, perhaps your lordship will be the best person to say. My lord, there was one liberty long back given in 2004. My lord, but that thing, my lord, which your lordship has rightly pointed out, that when this order was passed, wherein this fixation was done from 1997, based on the circular which was enforced, my lord, this actually came down to that. It is a fact, my lord. I know I have a very bad case, but I know this person is also pretty helpless. So I am really in a situation where, despite this letter which I am bagging, I actually tried to think. 98, my lord. There was a grand thing. My lord, again, my lord, if we go by this, if your lordship sees the words, my lord, with due respect, this is something which I understand was misconstrued by the person who was actually giving advice to this client. Because they took it as if this is something where the court has actually determined everything and it is just like a cake, you go and produce and you'll get it. Perhaps that is what window of hope. Exactly. That much. Exactly. You have to make a representation to the authority and say that, look, kindly do it. If not, then you go to OA. But that is what was not done.
Item number 8.
Blood 8, blood. I am for the petitioner led by Mr. Bikash Ranjan Bhattacharya. My seniors has throat problem. That's why, Lord, I am making appeal to your lordship. Kindly adjourn and let it be fixed on Wednesday. Yes. I'm really grateful. Wednesday adjourn. বলা একদম নেই। হুম।
Item number 9.
I am appearing for petitioner. No.
Yes, my lord. The other side, the Union of India have to file opposition. They seek opposition, my lord, on 20th September, and it was extended to 4th October. Matter was appeared on 20th November, madam. We have not been, petition has not been paid for 148 days. We are restrained by the authorities to perform duties in the railway, and tribunal only released 2 month, 9 days pay salary, my lord.
Mr. Kaushik Day is appearing by the government of India. Kindly. It's struck up.
Yes.
Sure.
Item number 10.
My lord, I am for the petitioner, my lord. My lord, a very short point is involved in this, my lord. My lord, I was absent, my lord. Charge sheet was served upon me, my lord. Unauthorized absent, my lord. My only contention is here, my lord, that I had submitted my medical certificate, my lord, before the appellate authority, my lord. I was mentally unfit, my lord. The only fault in this judgment, what I can show before your lordship. He has not submitted any document with the order or the this video. So before the appellate authority cannot take any action. He has submitted or yes, when he submitted before the appellate authority. Now, my lord, in the original application also I submitted those documents, my lord. They have not filed the reply, my lord. My lord, only opportunity should be given to me to that the medical certificate is to be considered. That's it, my lord. My lord, then I will be left out without justice, my lord. Because, my lord, here one thing is to be appreciated. My lord, kindly appreciate this, my lord. The ground for which I have not attended, my lord. My lord, from 12 to 2006 to 18.3. My lord, I was mentally unfit, my lord.
My lord, my lord, my lord. My lord, I have not joined, my lord. No, my lord. In 1995, I was in service, my lord. My lord. My lord. Constable, my lord.
Under the police regulation, Bengal 1943.
My lord. My lord, I filed 2008, my lord. My lord, I challenge the order of the disciplinary authority and I challenge the order of the appellate authority. My lord.
18/3/2006.
18 March 2006.
My lord.
And by inquiry report submitted on 8th August 2006. August 2006. And final order passed on 30th August 2006.
বাংলাতে পড়ো
30
বলছি আমি
August 2006. Page 22-26. Yes. Second show everything.
My lord, he এটাই তো আছে
Just given the charge sheet is updated and clear before the authority. To give some time to join. From time to time, we submit representations. Page 81. Follow.
বলছি দাঁড়া পড়তে তো না পড়তে Your lordship's attention to page 81, my lord. My lord, I gave a representation to allow me some time, my lord.
And member of a discipline board.
Page 81, my lord. My lord, may I take help of my learned friend, my lord, to read it in Bengali? My lord, this is the same with me, my lord. My lord, here I made a representation to allow me to join and then I will attend the inquiry, my lord, because I was not in a position, my lord. My lord, then some time was to be given, my lord. I was mentally ill, my lord. My lord, I am not on that point, my lord. At least this should have been considered that I am mentally ill, my lord.
With great respect to my husband.
Otherwise, comment was not given. One of Paragraph's comment was not given in the opposition also they have not given.
কারণ পড়বে না তারা বলছে আমি কোথায় দিতে এক্সাম দিতে শোনো এসব কিছু দাঁড়ো দেখুন না কি বলবো না Hello, I am better now, my lord.
So for time, some time.
My lord, he recovered from mental illness, my lord. He sought time, my lord, that give me some time, my lord. But the inquiry was proceeded. Oui, 81.
My
বলো
My lord, kindly. My lord, kindly come to page number 81, my lord.
2006.
Yes.
I can join within 1 week. Never done.
My lord, kindly see the appellate order, my lord. That is a cryptic order, my lord. Appeal.
Page.
Appeal, page 86. But page 86. But he has capacity to write all these things, being a mental patient. 4 pages application, taking all legal points. In 2000,
কি অনেক জজ আমি তো ভালো একটা জজ কি আছে এই অর্ডারটা পড়ো না পেজ 81টা
আরে 2 মিনিট বলবেন কত সুস্থ
বলেছে এত পেজ আছে একই বাংলা কি আছে এটা
আমি সুস্থ আমি সুস্থ যদি সময় দিন আমি থাকছি আজকেও কোনো দিন
হাজির হবো তো সময় দেবে তো হাজির হবো
ডিউটিতে হাজির হবো
এটা কি লেখা আছে
নাকি অসুস্থ আমার বাবা মাকে আমি হাজির হতে পারি না
এই লেটারটার ডেট কখন আছে
29
হ্যাঁ
29
29 তো আমি হাজির হবো আমি ইনকোয়ারিতে হাজির হওয়ার জন্য করছি
তারপরেও তো কেটে কিছু চাইনি
আমাকে তারপরেও চিঠি দিয়েছে ওরা
না
নেই এখানে
এই তো
একটি লেটার সার্টিফিকেট থেকে not the full. My lord, I have said that. My lord, I have said that if opportunity is given, then I will annex. My lord, I have read it, my lord. What is there, my lord, I cannot deny, my lord. My lord, I am only seeking that liberty that this should be considered, man.
No. No legal factor, body level, protection, normal, this is that, and body financial, no spondylitis, no outside please certificate. Yeah.
One zero, my lord.
How do you? Well, will it be produced before the? Order? State appointment also.
Please display. Display.
30th August 2006.
38, 2006, my lord.
It's 22 to 26.
The affiliate authority को मैं पास कुछ नहीं। I ordered the date of 13/3/2007. And my affiliate authority's order is 13/3/2007. After that, medical certificate has been issued, my lord.
And habitual absent.
My affiliate authority is passed on page 33, my lord. 13/3/2007, my lord. Page number 28. 8 circle. No. Eight of page 28. My lord, I'm sorry, my lord. Kindly come to page 28, my lord.
Of order in appeal. Page 28.
Kindly have prayerfully gone through the proceedings filed, appeal petition of such and such, and verify comments dated on the same schedule by the Commonwealth Mr. Charges have been provided. Due opportunities have been given to the charge constable in different stages. Inquiry has been conducted in conformity with the order person. There is no problem. There is a probable history of earlier delinquent.
So that can be a ground.
No, Madam, if somebody is absent for 3 days, another is absent, then Madam, he may be considered past conduct.
What has he said in his appeal? Can you find out from this appellate order what he has said in his appeal?
He challenged the order of dismissal.
What, on what ground? Can you say from this order?
Apparently from that, yes, where is the documents? That means he's applied his mind. So what is the decisions
He
taken
has
by
not even recorded what he has made out a case in appeal. We forget about considering this. One paragraph order. Now, inasmuch as charges have been properly framed, due opportunity given, there is proven history of earlier delinquency. The defense of the charge constable lacks documentary punch on account of non-production of medical certificate. That's all.
But finally see the.
Has he claimed in his appeal that he filed any medical certificate?
I don't find it from there.
No, he has not. So how can that be a ground?
On account of non-production of medical certificate.
So he doesn't say that he produced. He says I was mentally ill.
No, Madam. The appellate order page 20.
My lord, how can I produce? Medical certificate is after the appellate authority's order, my lord. And I was not given parawise comment also, my lord.
What parawise?
Parawise comment.
Parawise comment.
Dated 13/10/2006.
Appellate order. Appellate order.
Sir, don't make submissions like that.
I'm sorry, ma'am.
Please don't make submissions like that. Unless you are sure of what you are saying, if you want to assist, assist. Not to fudge the issue.
I'm sorry, ma'am.
Yes.
He received the charge. He was supplied with the charge. He did not reply to the charge.
That is all there in
Yes.
the.
Then Malad, inquiry was conducted. Report was supplied to him. No representation against the report. Second soap was notice issued.
Did he file a reply to the charge sheet?
No.
No, my lord.
Nothing. There also you didn't
My
file.
lord, I was ill, my lord. This is my case, my lord. And my certificate is also after the appellate authority, my lord.
Certificate is a very belated certificate. Before that, you have written so many letters and things which show that you are properly in a proper frame of mind. And you are saying because I was mentally broken down, I can't attend my duties.
My lord, kindly appreciate letters can be written by assistance also, my lord.
Can be. It would say that I am writing on his behalf because he is unwell. It can be. There is a scope. We are not saying it cannot be, but it is not here in this.
My lord, the medical certificate is to be considered, my lord, whether I was
Not a
whether I was really ill or not, my lord.
Ordinary counsel for the petitioner.
Right?
Number 11.
আবার কি দেখছেন এই যে তপন মন্ডল
The committee can be
দু কপি করেছে Yes. The issue involved in this petition matter has already been decided by your lordship earlier. This is the judgment of your lordship. Yesterday, my junior had the occasion to appear before your lordship. Kindly have a look. This is shortfall of service. Where
36 DCRB.
36.
36 DCRB.
This is the judgment. I have given a copy to Mr. Mukherjee also.
He wants to argue regarding Rule 4.
Yes.
Yes, we'll consider.
Again, he will argue.
He says that it was, in that case, a wrong provision was considered. Actually, Rule 4 of the DCRB is to be considered.
He has cited that provision to
No, but kindly see the order of the tribunal. It is
again, you
therefore clear that the applicant is an employee has not exhausted all the remedies available to him by furnishing a representation for.
You made no representation.
No representation.
Then how the tribunal has jurisdiction to go into the issue?
Kindly see section 21.
I will answer all this query.
That is a preliminary issue. Answer it.
Very well.
Then we can proceed further. The Administrative Tribunals Act requires exhausting of remedies. There is a specific provision, you know. Either you make an application or a representation, it is disposed of or not disposed. The period will vary. Unless you do it, how can you approach the tribunal directly?
I tell you, Lordship.
In violation of the statutory provision, section 20.
Section 20.
Section 20.
Well, may I start my case? Then I'll come to.
Please read, then you may assist. Read.
The application not to be admitted unless other remedies exhausted.
Correct.
A tribunal shall not ordinarily admit an application unless it is satisfied that the applicant has availed of all the remedies available to him under the relevant service rules to redress of grievance. For the purpose of subsection 1, a person shall be deemed to have availed all the remedies available to him under the relevant service rules as to redressal of grievance if a final order has been made by the government or other authority or officer or other person competent to pass such an order, unless such rule rejecting any appeal preferred or representation made by such.
Yes, that is the word in the provision.
May.
Yes.
Representation made by such person in connection with the grievance. Then, where no final order has been made by the government or other authority or officer or other person competent to pass such order with regard to the appeal preferred. Regard to the appeal preferred or representation made by such person if a period of 6 months from the date of which yes. Now, may I have a case here. May I answer to this? The provision is, for such purpose of subsection 1, a person shall be deemed to have availed all the remedies available to him under the service rules if a final order has been passed by the government or other authorities or officer or other person competent to pass such order under such rule, rejecting any appeal preferred or representation made by such person in connection with the grievance. Now, your lordship, kindly have a look to my case.
As many times you may read it, the outcome will be the same. A representation was required to be considered, and section 20 is couched in negative terms. The cat shall not, the tribunal shall not, unless this is done.
But now, may I have to cross the first hurdle.
Therefore, we are asking you to.
Your lordship, kindly. But why I have given this order to your lordship? There is a definite purpose of.
In terms of this order, you should. We don't know what you will do anyway.
But only 2-3 minutes I'll take. Well, this is a case where I have definitely there is a shortfall of 2 months 22 days.
Yes, you meet the hurdle of preliminary objection.
I will. But
we enter the merits of the matter.
Very well. But kindly give me 2-3 minutes time. If your lordship so
5 minutes.
Yeah, I have 5 minutes.
Then what you are asking.
Very well. I'm so grateful. This is a case where I was appointed in 2014, 10th of July, and I retired on 30th April 2024. Simple. Now, but there is a shortfall of
How does that overcome section 20?
But only 5 minutes left.
Oh, section 20.
I will.
Utilize this time to meet the issue of section 20.
I will. Let me come one.
It was not raised by the state council, but it is a statutory provision we cannot overlook.
True.
Yes.
True. The book is before me. The provision is before me. I am not here to argue on the on the merit of the case until and unless I overcome this hurdle. Kindly allow me for 2-3 minutes. The case is that I retired after rendering a service of 9 years, 9 months, 8 days. There's a clear shortfall of 2 months and 22 days. Now the issue is, if your lordship kindly takes a why I have not preferred a representation before the authority is at page 66. Kindly have a look.
Okay.
66. This is an interdepartmental letter issued by the senior accounts officer to the executive engineer, Baharampur Irrigation Department, dated 30th May 2024. Got it? Report on admissibility of pensionary benefit to the petitioner. Pension is nil because
you have challenged this order in the tribunal.
Yes.
Your relief.
My kindly turns to my my original application. Kindly sees relief sought for page 26. There is a delay of 82 days. Sorry, there is a shortfall of 82 days. But I have
challenged that order.
But I have said that
yes, your immediate response without even looking at the prayer was that yes, I have challenged that order. You have not challenged that.
But I tell your lordship, this is
by inference. You will say that it amounts to challenge.
It is because
we have understood what you are doing.
Your lordship is dealing with
in respect of this document. But lapse by you had the option of challenging. You were not challenged this also.
But in the
presentation, no challenge to the order pass.
In the your lordship kindly takes up.
We are here to see whether the tribunal has erred. We don't find. It says that there is a you have not exhausted the remedy, which is correct.
Now, kindly have a look to kindly
has not gone into the merits, only on the issue of non-exhaustion of remedies.
But after
the tribunal were to exercise jurisdiction, then we would have to interfere. Even if it was a good case, that without exhausting the statutory remedy, having regard to the nature of the statute, the provision which says it will not go into, it will not admit unless.
But kindly then, your lordship, may I humbly request your lordship, kindly grant me that leave so that I can approach the department, because the person will lose everything.
said so on the very first day when the matter was called.
Well, I was not there, but my
They have not exhausted the remedy in view of this judgment, they can approach the authority.
yes, but kindly grant me that. I'm so grateful to you, Lordship.
State, there is a shortfall of 2
Ajor Rapto.
Yeah, so the FLL in this letter, matter your lordship had very briefly heard, I mean, led by Mr. S.N. Mukherjee in the matter. Lord, obviously, my lord, the bench was not available and it has become available. My lord,
I'm sorry to interrupt, my lord. On the last occasion, my lord, your lordship, the order recorded is, my lord, that question of maintainability, my lord, has to be, my lord,
are there order
first.
today?
And I have taken the point of maintenance.
No, it's not.
May I, my lord, open the case, my lord, and
My lord, may I just make a request and then I'll leave it to your lordships, my lord. Matter was earlier fixed, my lord, in the first week of January, where your lordships are very kind, my lord, to indicate 2 dates. Now, my lord, they have also filed a GA, my lord, which was where, my lord, in the GA, they have prayed for fixing of consecutive dates. Now, my lord, this is a matter that is.
don't look into the.
No, I'm not. And I'll just make one submission and then I'll leave it to your lordships, my lord. I am the main appellant. He has a cross appeal on maintainability. Now, my lord, today, my lord, we are in some difficulty. Mr. Mukherjee is also, my lord, not available today. My lord, may I pray, my lord, some dates have been indicated subject to the bench's convenience, because this is a matter that will not, my lord, with the greatest respect, get over in 10 minutes. It will take some time. We don't stand in the way of a hearing, my lord. If your lordship is kind enough to fix 2 consecutive dates, my lord, then perhaps it can be fruitful progress, my lord, and your lordships can finally, my lord, decide it all together. Because, my lord, we'll also respond with the maintainability, with the merits. It's all intertwined. Not it really can't be divorced from each other.
The point of maintainability, I shall indicate. A writ petition was filed by the company, whose name your lordships would not find on record today. It was filed by the company and one of the directors filed, as happens. That filed the petition by a company is filed petitioner number 2 is a director. The entire petition, I shall place before your lordships in petition, the cause of action was of the company. Thereafter, my lord, after filing of that writ petition, my lord, it's a fight between brothers, my lord, dispute, so it will be Supreme Court made various observations, and ultimately, my lord, an order was passed by this court, by this honorable court, deleting the name of the company. So, my lord, the writ petition would show that the petitioner number 2, the individual, had no cause of action. As I said, the entire writ petition was based on the cause of action of the company, not of the individual director. Name of, my lord, the company was deleted, no challenge, accepted. Writ petition was not amended. So today, in my full submission, my lord, the writ petition ought to have been dismissed from the point of maintainability itself.
Name of the company was deleted in which proceedings? In the
Yes, in the writ petition by an order. I shall place before your lordship the order was not changed.
Thereafter, my lord, the impugned order.
So the question was whether, my lord, the writ petition by a director alone was maintainable. When the writ petition did not, my lord, in the writ petition there was no pleading of any individual cause of action. And I shall show your lordship, I shall start with your place before your lordship the order of the Honorable Supreme Court about the observations made by the Honorable Supreme Court.
But subject to your lordship's leave and Mr. Mitra's leave. Lord, no, because I didn't want to interrupt Mr. Mitra at all. Lord, these are issues your lordship will hear. My lord, I was only wondering, and my lord, this is a request and I leave it to your lordship. My lord, Mr. Mukherjee is in some difficulty. Any date, my lord, in the 3rd week of February, my lord, he was requesting if it commends to your lordship. My lord, of course, your lordship's convenience is paramount. My lord, 17th, 18th, 19th, 20th, if it.
When will you make your further submissions on maintainability?
I'm sorry,
when will you make your further submissions?
I can take it, my lord. I am ready to make myself.
Today. What's that senior should be available?
Very well, lordship.
Lord,
it's entirely on your lord.
Yes, and leave it to your lordship, lord. That's only a request.
Give us a date when finally it can
yes,
be.
my lord, if since your lordship has asked me that question, I've inquired from Mr. Mukherjee. I don't know Mr. Mitra's availability. 17th to.
We don't mean you, we mean you.
That's right, but 17th to 20th, not because the bench. Also, I don't know. 17th to 20th, or any of those 4 days.
Now the bench will be here as
Yes, and my lord, last occasion also, your lordship had fixed 2 consecutive dates. So my lord, we'll make the same joint prayer. The 2 consecutive dates we fix. 17th to 20th. 18, 19. Yes, my lord. No difficulty.
As Mr. Mitra has addressed the Yes, please give your opinion.
Great.
Mr. Mitro, can we invite your attention for a minute?
Yes. This is the matter. Oh, Mr. Mukherjee, I mean, yes, yes. The appeal. I mean, yes, well. My lord, can I do one thing, my lord? Can I have a talk with Mr. Mukherjee, my lord? Yes. Or before that also, I can come back and my lord tell you. Yes. Very, very. I will.
Take it on record. Mention it. Affidavit is taken on record.
Right, item number 12. Lordships, I am for the petitioner and junior with junior. Lordships, in this matter, 4 times Lordships heard the matter. 4 times. That the petitioner, that the respondent had challenged on the stepping up motion before the tribunal. And tribunal has not complied. The stepping up definition. What is the definition of stepping up? That not be followed and complied. And thereafter, I challenged the tribunal's order before and filed that before the challenging the order before the lordships. And the matter that is the petitioner and in added respondents and BL Narayan, it's stepping up.
And respondent Amarjit Singh is claiming the stepping up. Kindly see the all along he is a B.L. Narayan is senior to Amarjit Singh. And Amarjit Singh appointed in 1975. Whereas the respondent, sorry, my lord, B.L. Narayan appointed in 1975, and whereas the Amarjit Singh respondent is appointed in 1981. And all along he was senior, and pay scale is higher than Amarjit Singh, and one post is his senior post, and he's claiming stepping up. That is a rules has not complied. And stepping up, kindly see the page 26. Kindly see the page 26. What is the stepping up? And circular is also circular to the in earlier occasion lordships, in the circular, kindly see the circular. The circular is claiming he has not annexed. Kindly see the circular to the that is the circular 27 circular, sir?
27, 20 July.
20th July 2004. Thereafter, no circular has not been published. And page 26, that is the stepping up of pay. Kindly see D, first time D, kindly see. If a senior is appointed later than the junior in the lower post, itself whereby he receives the lesser pay than the junior. In such a case, also senior cannot claim priority the higher post, though he may have promoted earlier to the higher post. And circular also said the similar conception of the stepping up the matter. And stepping up will be counted from the date of appointment, not date of promotion. In the date of appointment 1971. You got all the 81, yes. Right. Okay. I did. Because I published. House to the E.L. Narayan added respondent is appointed in 1975. And whereas the Amarjit Singh is appointed in 1981, is claiming the stepping up. For one post, he is senior, and earlier all posts he is senior, B.L. Narayan, and his junior Amarjit Singh, and pay scale is higher than juniors Amarjit Singh. All along he is senior. May I submitting one thing, Lordships?
Yes. Just give us the details of your service. You are for the Union of India.
Union of India Railway.
Give us the details of the service of the applicant.
Detailed service that have and স্কোলা আছে তো কোথায় এন্ড করেছো হ্যাঁ যে নতুন এটা দিয়ে গেল না যেটা বুঝতে পারছি না নতুন দিয়ে গেল এটা কোথায় বুঝতে পারছি না বলে ইয়েস লর্ড that is the details of service kindly see এইটা একটু দিয়ে দিন না
It has not been annexed, my lord.
yes already honest it is eligible
And show
that is
from
eligible
show from the brief.
yes yes
Give it back.
yes
First from the brief.
eligible টা বের কর তো হ্যাঁ তুমি দেখো না কিছু এটা কি করে হবে অ্যানেক্স করা আছে জজ সাহেব তপব্রত বললেন না এলিজিবল বলে নতুন করে দিতে বললেন জাস্টিস তপব্রত বলতো তা আমি সেই জন্য দিলাম এই তো আমি দেখলাম এইমাত্র huh?
Page 31.
Page 31. Yes, page 31. Internal page 31. Inter
67.
67.
Internal page 31.
Internal page 31, page 67. That is eligible and there are lordships. Justice Topobroto Chakraborty direction to give the press. According to that, I am giving submit the press. That is eligible. That is legible.
No, page 31 is legible.
No, legible.
31, your lordship, page 61, internal page 31.
Internal page 31.
Page 67, your lordship.
Page 67.
67, your lordship.
Where is your reply before the tribunal?
What is the reply? Reply, page jana koto reply is very bhalo legeche. Reply. Reply page 85, lordship. 85 onwards. Kindly see the page 85. Okay. Page 85, kindly see, lordship. Page 2, paragraph 4, that is very relevant in this case. The applicant was appointed as a signaler on 16/10/1981 in the scale of page 26430 in Kharagpur division and joined duly after necessary training from ASNI on 13/4/82. Whereas the private respondent is B.L. Narayan, appointed signaler on 1/7/1975, and thus the applicant were junior to Sri Narayan by virtue of date of appointment. At that material time, both of them joined on two separate divisions in the year of appointment. An applicant was appointed pay of rupees 260 in scale of pay 260/430, and whereas the B.L. Narayan was getting pay 470 in the scale of 425 to 640. During stay of Khurda division, Sri B.L. Narayan got several promotion, being reserved candidates in different pay scale and transferred to Kharagpur division. and posted at Kharagpur 9299 90 as CHITT
What
in
is
the then,
CHITT?
yes,
What is CHITT?
CHITT. Actually, CHITT. DTI means such a divisional traffic inspector.
They are asking you
Ah,
what is
yes,
CHITT.
yes, ITT, that I know.
Why do you use abbreviation in the pleadings? Basic concept of not using abbreviation in pleadings, and you are using abbreviation.
Traffic, traffic, international traffic, traffic training হবে। কি বলছে? হ্যাঁ? ITT, so ITT রয়েছে, ITT রয়েছে, ITT, এখানেও ITT রয়েছে। Full form is not given. Then that is instruction, full form is not given. He is ITT, Khudda. Thereafter, DTI, divisional, this form is there, the divisional traffic inspector, DTI. Thereafter, next paragraph, Lordships. The applicant was promoted to the post of DTI, the inspector of category, and which pay scale with such and such, and BL Narayan, private respondent, was in pay scale such and such, with pay 2375. Page 87 is very relevant, that of merit of the case. And another, he filed an application before the tribunal. Tribunal passed the order and rescind order, and thereafter he filed an application. He has rescind order, passed the consider, he has not considered the authority. He has filed another application before the tribunal. This is the second time, and that is the tribunal. And second time, I'm challenging this disorder. The stepping up.
From the post of DTI, both of them have come as senior DTI.
Yeah.
Chief DTI.
Huh?
DTI, senior DTI.
Both of them were appointed in different divisions.
No, but in the post of DTI, they were both at the same point of time.
No, my lord. In 1997, the applicant, the respondent hearing, my lord, he was promoted as senior DTI.
Must have been after DTI.
DTI is a separate category of cadre. My lord, I came first in the capacity of senior DTI in 1997, promoted to chief.
Came at DTI in 95. Therefore, you had also come as senior DTI from DTI, and Narayan had also come as senior DTI from DTI.
Senior DTI, but later on.
So therefore, you said no. So that no was wrong.
No, my lord.
Both of you become senior DTI from the post of DTI. We are not talking about prior to that.
A chief DTI.
No. No, senior DTI.
Show your promotion order to the post of senior DTI. Where have you said in your OA that you were promoted from chief DTI to senior DTI?
Senior DTI to chief DTI.
Why are you saying something which we are not asking you? When we said something we were correct, you said no. From DTI, you became senior DTI.
From senior DTI.
Then you said
from
no.
Senior DTI to
Forget about after that. We asked you from DTI, you became senior DTI. You said no, which was
No, my
incorrect.
lord, I was thinking of
That
the
was,
chief
why
DTI.
should you think of something when we are asking you a specific query?
From DTI to senior
Senior
DTI.
DTI, you also became and Narayan also became. You became DTI, senior DTI in 95. He became senior DTI in 97. This is what you are saying. Senior DTI, you became before him.
Yes, sir.
You became in 97 and he became in 2001. This is what you are saying.
Yes.
And therefore you say that in the post of senior DTI, because I am senior to him,
Yes,
I am entitled to stepping up.
stepping up, yes.
He is relying on the rule to say that both are coming from different divisions. He has got many promotions in the earlier cadre. Therefore, stepping up will not apply. That is your
Yes. This is the case.
My case, if I start my case, my lord. But I was appointed in the year 1981. He was appointed in the year 1975. The private school. Now, my lord, through various avenues of promotion,
different divisions.
Through different divisions, I became chief DTI. If I restrict only to that extent, chief DTI in 2000, and he joined the inspector. He became chief DTI in 2002. Now, my lord, in the promotional post
of chief DTI,
I am the senior. And in the promotional cadre, my lord, the principle before the Honorable Apex Court and before the coordinate benches were that the past services or the total length of services in the feeder post becomes irrelevant
No,
if the incumbents, if both the incumbents joins the promotional. This is the principle which has been enunciated by the Honorable Apex Court and the coordinate bench judgments are there. I will be relying upon. And also, senior should not draw lesser than the junior.
This is a very, very settled concept.
Now, my lord,
service
now, my lord, why I say, my lord, kindly similar issue came
not
up.
a question. It is not a question of senior drawing a lesser. It is a question of stepping up.
Stepping up.
Now, you are claiming stepping up. Whether stepping up can be claimed by virtue of you being senior on the lower post only, or the entire service period prior thereto has gone.
Entire
He
service
says because they were from different divisions, he was a reserved category candidate. He got several promotions in the meantime. Therefore, you cannot claim a stepping up. It cannot be invoked.
No, my lord, that has
Relying upon this page 26.
Now, my lord, my respectful submission will be
That is his case.
that is his case.
What
My
the tribunal has held, let us see. Why the tribunal has not accepted their view and has accepted.
Now, my lord, prior to tribunal,
Let us see. First, let us see.
না না আমাকে জিজ্ঞেস করলে আমার বলতে হবে। কোনটা? ওই ওইটা নিতে পারি দরকার নেই। Using order পেজটা কত? 71 বললে using order। নামটা দিন, নামটা উল্টো পাল্টা। আইটেম নাম্বার লিখে দেবে উপরে, আইটেম নাম্বার 12 নোট ফলো করে।
So you are relying on which clause of Office Memorandum 41193?
Yes, my lord.
You are relying upon which clause of the Office Memorandum dated 41193?
Office memorandum. 41193.
Just now you said that you are relying on that document. Page 26.
Page 26, yes.
Which clause?
That I am coming to law. Clause D. Clause D. Clause D.
D.
Yes.
You are claiming stepping up on the post of CSDTI.
I was paid my lord at lower scale when I promoted to the post of chief DTI, and subsequently when the private respondent promoted in 2002, he was getting much more. But I was senior to him in the promotional cut, and that where the judgment, my lord, I have relied upon some judgments. You have to kindly take into consideration these judgments, because the rules were also cited over. These rules were also cited over there.
The earlier occasion, he has cited the Supreme Court judgment and
These rules were also cited over there. Revised rules were also cited over there. My learned friend is relying upon 93 rules. 2004-6 rules were also cited.
Yes.
But the principles, my lord, which I have placed just now, my lord, that was given precedence over these rules. May I take your lordship to page 73 for once?
What is page 73?
70 is in another similar matter, which came up for consideration before the Honorable Division Bench. Similar facts. Well, may I read for your lordship?
Internal page 73.
Internal page 70. Page 73 of the writ application.
37.
In the petitioners along with one, Boydunath Bhakt approached the tribunal for stepping up of pay, as according to them, the respondent number 7, although joined in the same cadre, later on got higher pay. The eventuality was considered earlier by the Railway Board, and the Railway Board by its circular number July 20, 2004 and 2020 and 2004 directly stepping up of pay in these cases, subject to the conditions maintained here.
My lord,
Just a minute,
just interrupted.
Why you are interrupting?
July 29, 2004 is no circular is there.
The petitioner.
There is no circular is there. Only circular is there to 28 July 20.
Very bad way of arguing a case. It will not serve you any purpose by interjecting whatever he says.
Now, one circular is published.
Yes, you keep saying whatever you want. You can continue all day. Not expected from someone like you. Yes.
Yes. The petitioner approached the tribunal for similar treatment. However, the tribunal dismissed their application by upholding the contention of the railway that they did not come within the scope of the said railway board circular. The facts would depict petitioner came from different channel of promotion than that of the respondent number 7. The record would show that the respondent number 7 joined much earlier than the petitioner. The records would show that the petitioner held a different post than the respondent number 7. However, admittedly, the petitioner joined the post of loco supervisor.
What this judgment stands, it was not assailed.
It was assailed before the Honorable Apex Court.
What happened?
Apex Court dismissed Railways appeal.
Let us see, where is that?
That is there at, my lord, page 74. Page 74, yes, page 76. But the question of law was open for the Honorable Supreme Court for consideration, but the finding and the judgment has been upheld.
Therefore, this is not a binding precedent. This issue was kept open, so this will not help you. Any other judgment?
Another judgment, my lord. But if your lordship so desires, I can use an affidavit, short affidavit.
No. If you show us the judgment, what affidavit now? What an affidavit?
Another, relying upon that division bench judgment, my lord. Another judgment, my lord, on the same.
That judgment considered the Supreme Court judgment.
That the ratio of the division bench judgment.
Second judgment that you are citing, it has considered that the Supreme Court has left the issue open. Let us see.
Yes. Supreme Court judgment.
In which paragraph it has considered the Supreme Court?
May I take your lordship?
কত প্যারাগ্রাফ কত আর বইটা পড়বে তো একটা কপি দাও আমাকে give me a copy.
This way, my lord, every time, my lord,
show us.
Very difficult to place.
There is reference to the Supreme Court judgment.
এটা শুনেছি
Is the SLP civil number 5901. Yes, where is 5901? Let us see.
My lord, if your lordship kindly take from paragraph 2, page 2, last paragraph.
We are asking you to show where the Supreme Court judgment has been considered. You said yes. When you said yes, we thought you have seen.
Yes, my lord, page 3, internal page 3.
Yes.
In reply, Mr. Singhania submits that the judgment delivered in case of Shyapada Roy Supra was challenged by the petitioner.
Yes.
Hearing before the Honorable Supreme Court, and though the SLP was dismissed, the court observed that the question of law concerning the interpretation of relevant rules is left open. We have heard the learned advocates appearing for the respective parties. Now, my lord, kindly see the last paragraph. It is well known that a decision is an authority for what it decides and not what can logically be deducted therefrom. Even a slight distinction in fact or additional fact may make a lot of difference in the decision-making process. In case of OP Saxena, the court was considering the effect of grant of benefit on the category of running staff, and in the same, an option was exercised by the incumbent concerned to remain in the category of running staff, whereas the other opted for being promoted to the supervisory category. The judgment in case of Surendra Kumar was also delivered, taking into consideration the judgment delivered in OP Saxena. The said judgments are thus distinguishable on facts. The proposition of law laid down in the case of Shyapada Roy, which I have annexed, is squarely applicable to the facts of the present case. My lord, the proposition of law laid down in case of Shyapada Roy, squarely applicable to the facts of the present case, and the SLP preferred against the same was also dismissed. Here also, the point of law kept open is for consideration of the Honorable Supreme Court. My lord, SLP was dismissed, the only point of law was kept open.
The legal position as to under which circumstance a person would be entitled to stepping up because of anomaly on the existing post or because of an anomaly on right in the earlier stage. This issue was decided in Shyapada Roy.
Yes, and also it was decided here.
So it was upheld by the Supreme Court.
No, Supreme Court, my lord, didn't go into that aspect.
No, Supreme Court left it open.
Left it open.
That means that it was not an issue decided.
No, my lord,
that means it was not an issue decided.
The proposition, so far as these two judgments are concerned, my lord.
You have any other judgment? If you have any other judgment, show it. Therefore, we are No, what comes, it is listed today. He says already 4 times it has been
He
heard.
can say whatever he find because
He says 4 times it has been heard. Now you
maybe I have not there for 1, 2, 3 occasions.
said at the very outset that 4 times it has been
I
heard.
join issues regard to that.
This is how he appears in the matter. He is interjecting before the.
Then in that case, my lord, I should be at least given an opportunity to come up with some authority.
No, you have. We are.
Because if
Today is the opportunity. Sir.
ultimately Lordship decides
Today is
against
the
me,
opportunity.
then in that case I should at least.
Don't know. Therefore, we are asking you. You are relying upon a judgment.
Yes, I am relying upon division what
you are relying upon a coordinate bench judgment
to
which has summed up, yes, on one judgment. The other is relying upon this. It is not a separate judgment.
But 2 different division benches.
There may be 10 division bench judgments, but they are all relying on Syamaprada Roy. And Syamaprada Roy, the judgment is based on a law which the Supreme Court says we leave it open. So therefore, will it be deciding an issue of law, or it will be confined to that case, or it can be followed as a precedent? This is what we are asking you.
But if I only Lordship allows me to read one paragraph, page 73.
We will read 100 paragraphs for answer this question first.
I have an authority on Supreme Court cases on this particular aspect.
Show it.
But I thought, Lordship, I will at least explain at least so far the proposition of division bench's order is concerned. If you
Not required. The Supreme Court has left it open. We want to see the law elsewhere if you can show it. Or you show us that it constitutes a binding precedent. You show us any judgment which says that even this kind of a judgment, which the apex court has said that the issue is being left open, that will constitute a binding precedent.
Well, 2009 volume 3.
Yes.
Supreme Court cases 94. Paragraph 17. My lord, the ratio, the ratio is the stepping up of a removal of anomaly. Held senior cannot be paid less than junior, even if anomaly in senior stay is due to difference of incremental benefits. Seniors pay therefore.
Which paragraph of
this? Paragraph 17.
Huh?
Paragraph 17. It's a very short judgment.
Just give us
paragraph 17. করে নি একটা কপি আছে 2009 volume 3 Supreme Court cases 94. May I read, my lord?
Yes.
My lord, what is troubling, my lordship, I understand, my lord. The length of the service of the private respondent is higher than me. But that is the aspect which the Honorable Division Bench has categorically stated on 2 occasions, that past service in the feeder post is of
Again,
no concern.
you are trying to take us to the division bench judgment again and again without clearing the query which we are asking. Whether it constitutes a binding precedent.
No, it has some persuasive value, but I cannot say that it has a binding precedent.
Then, yes.
May have some persuasive value, but my contention is very clear before this honorable bench. Is this I admittedly
And the provisions contained in the circular, page 26.
26,
which are not assailed by you.
No, it has not been assailed because I relied upon the division bench. The facts are similar.
Before the CAT, you did not rely upon the single division bench.
Before the tribunal, my lord, my all and all, I relied upon the honorable division bench judgment and the principles underlying it.
Where is reference to the division bench judgment in the CAT judgment? Let us see.
No, in the earlier CAT order, my lord. Not in the present one, he had relied another Supreme Court judge. That is A. Madhavan case.
Yes, that we have seen, but you are saying you relied upon the division bench.
I annexed all the papers, my lord. I have categorically
no better than to make such submissions. Yes.
Then, my lord, may I say this only, that if your lordship kindly turn to at least for once at page 73. Page 74, rather, internal page 2 of the order, that Mr. Roy has drawn our attention to the affidavit in opposition, wherefrom we find that prior to the joining of promotional post, as above, the respondent number 7 was working in the post of passenger driver, attracting higher pay than that of the petitioner, who were goods driver, being the feeder post.
Again and again, you are
in our view,
placing the same paragraphs thrice will not make the situation different. You have already placed it once. Why do you want to prove the same thing?
Well, I have the rules.
You have read this judgment
from when the honorable division bench judgment.
Yes.
When this division bench judgment came, my lord, these rules were already there. These rules were shown. They were relied upon, but that not taken into that it had any binding effect upon the outcome.
That's all then.
No, I should get an opportunity, at least, my lord.
What more opportunity? You have been arguing for 25 minutes.
I should get an opportunity to file my affidavit, my lord. It's in the admission stage, my lord.
Nothing beyond.
Because if my learned friend is no,
I have. We are only confining to the CAT records. There is no question of any opposition now.
Because I will only there are
any others. So if you want to cite any judgment, show us. We are
no, my lord. May I
see the issue of law? What opposition is?
Now the thing is this:
the facts are not disputed as stated in the WL.
No, I am not disputing the facts. I am not disputing
the law.
No, my lord. The rules, my lord. May I say only this: that the private respondent, before joining the DTI cadre, he was in a signaler group and he was redeployed. The word was used that he was redeployed in the inspector category. So, when a person can be redeployed, when there was a surplus, the rules is quite specific. Kindly come to page 81 for once. Well, the words redeployed has been used in the speaking order. Kindly come to the middle portion, the seniority of surplus staff on redeployment. Page 81. it has been decided that the service rendered by the surplus staff prior to redeployment will not be count for seniority and promotion in the absorbing unit department. Such employees are to be treated as fresh entrants in the matter of their seniority promotion. So once he joins in the promotional post, he has to forego all the seniority because he has been redeployed. That is the exact word which has been used in the speaking order. Well, kindly see what they have used in page 71.
81.
71 is the rejection as per the tribunal. Well, the consideration was made by the tribunal, by the authority as per the tribunal's order. They have used the word redeployed. So when it is redeployed, my lord, he has, well, his past service and seniority cannot be taken when he joins the abroad.
We will not say that he is to be treated as your senior. We will not say that. Don't worry.
But thing is this, my lord, both are on the same cadre. On 2002, I was drawing less.
Accepting your submission that it is a case of redeployment, he will not be your senior.
I am shouldering the burden of as a senior employee for 2 years.
The issue is not of seniority. That's why we are saying we will not say anything about the seniority.
And the, my lord, so far as the judgment of the impugned judgment is concerned, my lord, the learned tribunal was pleased to rely upon an honorable apex court's judgment.
Yes, now let us see that judgment. What is that?
Page 100 is the.
That is part of the paper.
Yes, part of brief.
Yes. No, where is the Supreme Court judgment? That has
Supreme Court judgment is at honorable apex court judge is at page 107. Kindly come to
Difference.
page 109. The ratio, the middle portion on considering FR 22, which provides. This has been taken into account by the tribunal. My lord, the ratio is at page 109, that on considering FR 22, which provides for stepping up of pay and the removal of anomaly by stepping up of pay of a senior on promotion drawing lesser pay than his junior, that by the impugned common judgment and the order of High Court has allowed the petition and has directed the appellant's hearing to step up the pay of the respondents, keeping in view the pay scale which has been granted to the juniors from the date they have started drawing lesser than the junior. And also, at page 112, it is stated quite clearly, my lord. Therefore, it was a case where a junior was drawing more on account of upgradation under ACP scheme, and there was an anomaly, and therefore the pay of senior was required to be stepped up. Hence, in the facts and circumstances of the case, the High Court has rightly directed the appellant hearing to step up the pay of the original petitioners, keeping in view of pay scale which has been granted to the junior from the date they have started drawing lesser pay than their juniors. That is from 2002. When he joined as chief DTI, he was getting more than what I was drawing. Accordingly, my lord, the same facts and situation, my lord, this has been relied upon by the tribunal. My lord.
That's all.
That is at paid in the admission stage, that is but your logic grants me sometime that I will equip myself with further. That as per my learned friend, I have not received any further. But this indulgence I should at least receive once. He has received fourth. Come tomorrow, my lord. No, may I say only one. Let it be, my lord, on next week. Kindly give 1 day. Time is.
No, I have no objection. I have no objection.
Grateful.
I have no objection. Lordship, may I pray you one thing? Item number 30, that is paying on one. Ask the Lord.
Grateful, my lord has given a patient here.
Yes, Lordships. I oblige to you, Lordships.
Great.
Item number 13. I am for the petition.
Yeah, no, it has not. Lordships.
I appear for the petition. Only point for consideration, shortfall of service. In one case, two petitioners before your lordship, 2 years something, and another less than 2 years. I have stated it. 7 months. 7 months. 7. Yes, due to laches on the part of the authority for recruiting us. For recruiting us within the time frame of the selection process. It is the fault on the part of the authority. Selection process of 1995. Due to some court cases or intervening by the honorable court, the process of selection was stalled. Ultimately, selection process again started 2007. We have been given appointment 2009. And by virtue of this passage of time, we lost our valuable service period. Now, we immediately, the authority also condoned, our employer already condoned our shortfall of service for the purpose of getting notional benefit in terms of the rules. This year we lose part 1. Now, authority, the approving authority did that from 1995 till our date of appointment. 7, because of the fact they have not proceeded due to the court's case, my lord. Now, ultimately, for the purpose of getting pension, it has been mentioned that their shortfall of service or overage should be condoned, meaning thereby in future so that we cannot be withheld by this purpose of course. Yes, now I'm just 2 minutes. Now, immediately thereafter, our employer conveyed before the appropriate authorities, upper authorities, for approval of this same. But they are sitting tight of the matter. We made representation before the authorities after determined. Nothing done. Tribunal was approached. But tribunal, in the first round of litigation, directed the authorities to take a view or decision in the light of the settled decision of this honorable court. Reached its finality. That the honorable division bench set it that issue. That if anything done due to purpose of this act of the court or something else, or due to stay of or litigation, that for that reason the litigant, being the employee, cannot suffer. Act of Latin term is there, and that I have that judgment 2010 volume 4 SCC page 419 paragraph 60. I shall. Now they have restricted within the periphery of that judgment itself. The authority again take it that no, since the statute does not permit, we cannot follow the court order. So again rejection. Second time approach before the tribunal. Tribunal again, my lord, returned that. So purposefully, this judgment of the tribunal I have assailed, but cannot. Again, it cannot be, because it is the tribunal's duty to decide the issue, but he did not. So at the faggot of our life, but one of the Supreme Court judgment I have also got today. I am no.
No, we have passed an order. No. In terms of the order of the tribunal.
Rejection করেনি, ওটা consider করেনি।
After the demand, we have passed an order. After this demand. No,
after that, no decision.
Order pass করে দিন।
No, they have not taken any decision. That point also decided. Opposite, there was a direction they did not avail. Your lordship's order is there. That is why, other day I did not oppose this, because settled position of law, let them file an opposition. Although they did not avail. So we are running out of age nowadays. And this is 2 months, almost order was passed long back in the month of December, and we are in the fag end of the January. On the very outset.
Perfectly correct.
I am opposing this. In this case, I am opposing. Facts are not disputed. Let me place my case within 5 minutes. Because the persons concerned are running out of their age. Retirement 2018.
18 and 16.
16 and 18. Immediately thereafter approached 7 years by tribunal and my lord. And And I have repeated requested him to give the opposition out of court. I am saying so. He says junior is to do 7 times. It is not done, my lord. I leave it to lordship, my lord. I am placing their order itself. My lord. By 10 days. But they have not done by 7 years. They cannot. And he is taking, and we have the experience with him. What about the judgments with him in his favor, different courts, he will side, not others. I do not. That is why I have brought his judgment first. I have to place. He could have placed before your lordship that judgment, because that judgment is earlier than your lordship judgment. Yes, yes. And not conflict. Your lordship also grant with some consideration, and their lordship held mandatorily. That is the only difference. Grateful to your lordship, my lord.
Number 14.
Or may I hand over those judgments to your lordship today? It is beneficial for us. And compilation of judgment I am giving all. আর 112টা তোমার হ্যাঁ সব দেওয়া আছে ওখানে আরে বাবা তপন দে judgment আচ্ছা আমি বলে দিচ্ছি আচ্ছা 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 কি বলছো তুমি page 21 he is not believing us তোমাকে লাগবে একটা আচ্ছা অলরাইট আমি তোমাকে একটা কম্পারিজন দিচ্ছি গ্রেটফুল টেলার
My lord, I'm appearing for the petitioner, my lord. Mr. Borun Chatterjee has been appearing in this matter. My lord. There's an interim order, my lord.
Not today is already. On prayer of the learned counsel for the petitioner, in presence of the
And for the respondent, my lord. Night out. No, I am for the respondent. Can you indicate the tribunal source whereby the tribunal rejected the application? I am doing. Yes, particularly against the rail.
Number 16.
May it please your lordship, I am appearing on behalf of the advocate and the court, my lord, who is ill, my lord. Kindly adjourn for not this week. Adjourn for this week only.
Item number 17.
I am appealing for the Union of India. In the last occasion, the matter was fixed for judgment, lordship.
My lord, I said I want to say one thing. I made all the prayers in support of Supreme Court judgment and High Court judgment. So please consider all the things. One who is judgmented. Judgmental.
Judgment.
Item number 18, my lord, I am appearing for respondent number 3.
Or I am appearing for the petitioner widow. And here also the point for consideration before your lordship, whether past service of the husband of the petitioner can be counted for the purpose of getting the pensionary benefit. And I had, as per their 1981 initial appointment as temporary post in a sanction post, worked for 14 years, and thereafter process of filling up the permanently, initially 1997 permanent, retired on 31st of August 2004. And the authority of my employer also, in this case also, as per 39, yes, 7 years. So if I am to be considered for that 14 years, then total length of service 23 years. But kindly state why, kindly come to page 39. Temporary is Khalasi in the workshop. I have stated in also paragraph 4A. In Lower Damodar Construction Division, page 5 of my petition. Regular basis in the month of February 2000, in the post of master role of personnel, Mozdur role, personnel, Mozdur, no sorry, master role of personnel. Yes, it is there. Page Mozdur, it will be Mozdur. Master role personnel is further added, and upper age limit of that is considered. Page 39. Under the Lower Damodar Construction Division. And they have made me that those who have been appointed during this period, taking into consideration of my temporary, their upper age limit for appointment should be considered and hereby considered. Hereby condoned. Kritish, yes. In that particular 28th of February to 1997, kindly sees. And thereafter, next page, with all this, page 41 also, serial number 64, Kritish was there in the permanent cadre. Yes, that was Yes. I'm giving this. Yes. Now last page impugned order says, since I did not work for 10 years, impugned order, my lord. It is in the impugned order. Yes. No, representation was made. The authority did not consider. No order the as per my husband made an application. So yes, and during the pendency of the tribunal application, husband expired in the year 2020.
And by an MA, by
Substitution done. Now my specific pair, that pension from 2004 to 2020, area pension of my husband, if my real lordship allows me to, and thereafter family pension with all benefits. And one pair has been made. I leave it to your lordship regarding interest part. I have made a pair. If your lordship allows this, otherwise I shall abandon at this point. I may confess to your lordship. So, kindly see the rejection order itself and their reply also. They did not take those, please. At page 50.
our reply is that
Page 57.
57 and 58, 59.
Page 58 is the relevant part. They did not take any plea what tribunal held.
Relevant
Totally on the basis of submission. And it is admitted fact.
Paragraph number 2 is the relevant submission.
2, 3, 4.
2, 3, 4.
From করবে না
কিছু আমি বুঝতেই পারছি না। ওটা
এই তোমার এই যে যেটা আছে দেখো the statement make up such and such
দেখে নিয়েছি মেল তো আমি
ঠিক আছে সুপ্রিম কোর্টটা কোথায় আছে Yes. And here's now another aspect of the matter. The page 89 kindly come. No, this is the judgment of our High Court on the pattern the point, whether temporary service in the government cadre can be counted. No, that is not. That is not. Now they are not also disputing that. They have admitted all. Neither are not there. No dispute. Admitted fact. Oh, acha. Maybe there. But in page 39, they have also said that our upper age limit should be condoned, meaning thereby that we have to get some benefit of that. First paragraph of page 39. Yes, my lord. And if your lordship kindly sees parawise by parawise of that, their reply as well as the submission of the learned advocate present there in the impugned order at page last but one page, totally contrary to that pleadings. Only on the basis of submission, 10 years was not completed. Therefore, under the rule, we are not entitled. Totally pleadings go by. Yes. And that too, that judgment of division bench as well as the Supreme Court was given to tribunal in the written notes. Also, not taken on record also, and the type of submission. Well, can you see this type of order passed by the tribunal itself? And in the written notes, I have given that limitation part as they pleaded. 1995 Supreme Court at page 97. And all these things has been given by way of written notes of argument. But kindly see that I have annexed the written notes itself. It starts from that judgment with the written notes. Written notes yes, this is from page 75. Written notes argument on behalf of the applicants along with these annexures. That is why I have annexed all this in compilation. Judgment of 14.3 CHN SL 1995 5 SCC. Now page 89. For the purpose of temporary service will be counted for the purpose of getting pensionary benefit. Paragraph 3. Yes. Similar set of facts. Paragraph 3 onwards. Paragraph 2 is the fact 3 and paragraph 13 onwards. Quoting all these rules. 9, 10, 2, 3 paragraphs kindly. Paragraph is 91. Issue formulated paragraph 1. So far as this subject to correction, but I may be wrong. This temporary service, your lordship may not. I may be wrong. Your lordship, that 6 months in respect of Rule 36 has been considered, but this is slightly different to the fact. My lord. It is not question of condonation itself. My lord. 17, 4, 6, 9, 12, 22. And I have given that compilation. All this judgment of this Honorable Court, including Supreme Court SLP dismissal. Yes, I leave it to my lord. Obliged to you. No, even the judgment has not been quoted. I have given page 75 with this written notes of argument. But kindly sees how the tribunal can deal with. Page 75 kindly sees the written notes. At least submission should have been recorded or judgment should have been considered. Page 75 kindly sees. Written notes of on behalf of the applicant totally go by. And tribunal is doing this. repeatedly. And probably my lord, this order was passed in terms of the আগে আমরা হাইকোর্টে ছিলাম না এটাতে না এটাতে হ্যাঁ কইলে সেটা হচ্ছে কোথায় রে জায়গাটা জাস্টিস চক্রবর্তী জাজমেন্ট কোথায় পেজ P4 পেজ কত I'm placing on P4 কোথায় এটা ওনাকে ডাইরেকশন যেটা দিল
That is at page 71.
Yes, 71. Yes, well, page 71 kindly sees. I am thankful to you. And this honorable court directed the tribunal to pass an order. Page 72 with some stick observation. Last but one paragraph, page 72. And that lady are waiting since then. Totally, that observation of the court itself, Supreme Court has been gone by at the time of passing the order. I say it is an order, not any judgment, I can say. Just submission recorded, not done. And page 96, that order of Justice Matre was assailed against before the Honorable Supreme Court. SLP dismiss. Page 96. Yes. No, rule, page, rule, rule does not say so, but taking nature of our service, that even in a temporary post, that should be counted. That in the judgment, paragraph 13 onwards, page 93, rule 17 considered. Paragraph 90, page 93, paragraph 9 onwards. Mentioned there. I am grateful to your lordship making that is rule 17 itself. That is considered there. Yes. Page 93, paragraph 9. I am obliged to your lordship. That is, I am placing this judgment in all the rules. Rule 18 considered, rule 22 considered, just I have submitted. Just now your lordship querying me that rule 17 was considered or not, it is considered. Appointed either substantially or in the officiating temporary capacity. One, my lord. My lord. My lord, grateful. Grateful to lordship. And discussion from paragraph 13 onwards. The point is not res integra before any authority concern. I leave it. And my lord, all other judgments, compilation, 13 judgments I have handed over. Kindly quote this section.
On the last occasion, I was handed over a bunch of judgments. I'll be very, very honest with your lordships. I have gone through the judgments. 36 gives the authority only to condone 6 months. Here it is 2 years. কত আছে last এ?
3 বছর মতো।
Almost 3 years. Almost 3 years. So 8 months. 2 years, 8 months. And I have gone through judgments, and our High Court has also pronounced a judgment. Paragraph number 18, just lordship sees once. 18 of the judgment, Nimai Chandra Chatterjee versus State of Bengal. Yes, that's
Madam.
what I want to say. I really don't know. I'm falling short of words. I have been very honest with your lordships.
Thankful to you. And my other day I handed over the bunch of judgments.
Yes, and I've gone through each and every.
Streams, you perimeted you with all this.
No, in 2 or 3 judgments, your lordship, there are specific circumstances which have been made out. That I'll have to again go through because it was, but
lady, old lady,
yes, but
getting
yes.
squarely applicable. Squarely applicable and upheld by the Honorable Supreme.
It's the field and it is upheld by the
My lord. And following that, Nimai, all other judgments are there.
Yes, take down.
My lord, in this matter, I am appearing for the response number 3, my lord, for the office of the accountant general, my lord. My lord, this is the issue between the employer and the employee, my lord, we have nothing to say this, anything in this, my lord.
Has been recorded in the last order.
Yes, yes. I'm thankful to you, Lordship, but yes, reminded us.
Borun.
6. Filing by filing? Filing? Mr. So submits that he will be filing his wakalatnama in the department today.
আমার টাইম চলে না
টোয়েন্টি,
নেবেন যেন সাহেব 19 নম্বর
My lord, in item number 20, my lord, Mr. Orpu Chakraborty is appearing on behalf of the petitioner, my lord. So humbly seeking, my lord, for 1 day accommodation. Well, kindly 1 week accommodation, my lord. I'm grateful.
চক্রবর্তী নামে কিছু অর্ডার করছে
21,
My lord, in this matter, my lord, Mr. Pinaki Ranjan Bhattacharya is appearing for the petitioner, my lord. Chakraborty, my lord, he is appearing for the petitioner, my lord. He has not come to court, my lord, due to illness, my lord. Take for not this week, my lord. My lord, we have already concluded our argument.
May I recapitulate for 1 minute? This is relating to that, my lord. Order or penalty was passed 14 years after the submission of this person. The allegation was that I didn't marks.
Mark sheet.
My lord, it is there, repeated, my lord, for cases where order of tribunal was the order. Ultimately, my lord, last opinion, tribunal of because the order was passed. Because the order was passed. After when the order was passed, my lord, the petitioner already attained his superannuation after completion of his duty. This is the position, my lord, heard the matter for days together.
Can you please, we are unable to understand what you say. After this,
my lord, the order under challenge was passed on a date when the petitioner has already attained his superannuation.
Attained his
superannuation.
Retired.
The order impugned was stayed by the learned tribe. My lord, your lordship directed me on the earlier.
So there was no occasion to issue the punishment order.
No. Punishment lastly, my lord, this matter, my lord, it is there. If I can open, my lord.
You were saying that the order was issued on the day, last day, the date of his superannuation.
Yes, he has attended superannuation. An order was passed by the authority after 14 years. That was stayed by the learned tribunal, and the petitioner was working. Ultimately, he has attended superannuation as on the day of disposal of the application before the learned tribunal. Now, my lord, these are the list of cases, my lord.
So then,
yes,
we don't remember.
I see.
You can't start off from.
I see. My lord, petitioner was a postal assistant.
Petitioner was
postal assistant. He was appointed as far back as in the year 1983. 1983. Yes. 1983, he was appointed, and thereafter, my lord, sometimes in 1990, my lord, the charge sheet was thought to be served under Rule 14. My lord, the petitioner approached, my lord, the tribunal, it was stayed, and repeated order, my lord, from time to time on each and every occasion, because the tribunal's direction was never complied with by the authority.
Thank God.
They went on according to their sweet. last case was filed, my lord, in way number 93 of 2019. Only one article of charge was there. That's why I did not produce the original mark sheet. And from the inquiry report, my lord will find that the.
Why you did not produce the original mark?
No, no. Yes, I produced, my lord. That has been recorded in the inquiry report also.
No, the charge memo is requiring you to produce the original mark sheet.
Yes.
Where is the charge?
Your lordship will kindly see. My lord, it is also at page 15 of the supplementary affidavit, my lord, the thicker one. Because in the read petition, my lord, nothing was there. All the papers were not there. At page 16, my lord, we find only one article of charge.
What the tribunal has done.
But I stand corrected, my lord. These the charge sheet which I have shown. It was the charge sheet, my second charge sheet issued in 2000, which was set aside by the London bench. The first charge sheet is, my lord, at page 140. No, my lord.
140 is the inquiry report.
No, inquiry report. I'm sorry, my lord. Your lordship, we kindly come to page
84.
Yes, my lord. This is here. Page 138, my lord.
138.
Yes, sir. It starts from page 137. The article of charge is, my lord, at page 138.
There is a typed copy.
Yes, typed copy also.
Submission to पेज नंबर से बोले बोलते
What is the date of your retirement?
My lord.
Date of superannuation?
Yes, my lord.
30 November 2023. আমার submission কি হবে?
পারমিশন কি
কত আছে?
23
30 আছে। You know what proceeding around?
Two 2019.
Yes, my lord.
Again, it was initiated.
Yes.
Again, it was initiated.
Yes, my lord. Initially, my lord, in respect of the charge sheet, my lord, 1990, my lord, the proceeding was going on. One after another order was passed. The petitioner was allowed to discharge his duties and functions. At the point,
There was a direction to remove you.
yes, yes, that was
You were not allowed to continue. There was a direction.
no,
to
that
remove you.
that was my lord stayed.
You went up in appeal.
And even in appeal,
They have said that yes, you should be reinstated.
yes, that
And
is
therefore, in 2006, you are reinstated.
yes, my lord.
But at the same time, the appellate authority said to proceed de novo.
Do you know?
In 2000,
De novo, my lord, from a stage, particular stage.
right? In 2006, it said
Yes.
to proceed de novo,
Yes, yes,
which you say they have started in 2019
yes,
after 14 years.
yes,
For 14 years, they did nothing.
yes.
This is what you are saying.
Yes, and for 14 years, there is no explanation of delay whatsoever. Further, why I have been,
At what stage the tribunal was invoked?
Well, the tribunal was invoked, my lord, at a point of time, my lord, challenging the order sought to be passed, my lord, in 2019.
What is that order? Oh,
That order of dismissal. That order of dismissal.
Where is that order?
I'm saying.
Disagreement.
আমি ধরে এগুলো করে দিচ্ছি না বোঝা মুশকিল। ঠিক আছে, Lordship, kindly bear with me. That will appear on page 27, my lord, of the
Page 27 of
no, I'm sorry. Page 22.
of the
Petition.
Note of disagreement was sought to be served, my lord, in 2019.
what happened after this?
But what happened, my lord, this notice of disagreement was challenged before the Landed Tribunal. Landed Tribunal was pleased to stay the operation of this matter. Accordingly, when the petitioner continued, that would appear, my lord, from the order under.
It is this order which continued to be stayed.
Yes, my lord.
It is this 2019 order which was stayed.
Yes, my lord.
By order passed in which way?
But way number 350 of 2009, 983 of 2019.
Where is that order?
Yes, my lord.
Can we see that order?
Page 27 of the main petition, my lord. এই অর্ডারটা হচ্ছে 25/6/2000 P9 22 জুলাই 2009 এরপরে এটা হয়েছে
What date is stay was of Which date? Stay order. You are showing us the final order. We are asking you where is the stay order? At least give us the date on which it was stayed.
That. I have to.
Right, so we filed it after this, must have been filed in 19 only, therefore it was stayed. Continued to be stayed till final disposal. And disposal is after your superannuation.
Well, that is at page. Hmm. 267 supplementary. It is
260.
267.
Yes, yes. Three, acha. It number not.
So no number দেওয়া আছে কেন?
61.
267 supplementary. Since the case has been made out to be.
Yes.
Now, may I please read a few paragraph of the inquiry report?
It is an inquiry report now.
That's true.
That is totally irrelevant now. Because it has already been decided in your favor. It's from that stage that it was to be started, where the disciplinary authority was to communicate his note of agreement assigning tentative reasons.
Yes, of 2006.
Therefore, the inquiry officer's finding is already that is in your favor.
Inquiry officer found me not guilty.
Correct, in your favor, that's what you're saying. What have you, they said, why it took them so many years?
That is what I have, why I have submitted. The inquiry officer recorded it. According to me, it was submitted with its superintendent of South Presidency Division, the original marks.
Sir, we are asking something else, you are saying something else.
No, I could not follow.
You are saying that why it has taken them so many years? What have they said? About 14 years.
Nothing has been said. Nothing. No averment, my lord.
No, he has made some submissions on the last day. We remember.
But that is a submission from the bar, but
the submission is that there is no delay in initiation. It is a continuous
Is this
process.
continuous process,
Therefore,
madam?
in the process, if there is a delay,
yes.
And delay happens in court also. That was also a submission.
Yes, but your lordship will kindly consider.
And overemphasis on delay, ignoring the merits.
My lord, may I then be allowed
Not
the government's
desirable.
Yes, my lord.
The verification report.
Only one thing I will. Yes. No, 83.
83.
There is an office memorandum from DOPD of 1971, which says it has to be completed within 6 months. Yes, I have handed over it. Sir, they have again copied it. Not only that, my lord, your lordship can be. Allow me, my lord, to produce what is the Supreme Court's observation so far as completion of inquiry procedure, when it is to be completed. Though it is with respect of, my lord, the suspension and any other or
So, there, all these things have been considered by the apex court in several judgments. One of the leading cases is Bani Singh judgment.
Bani Singh,
Don't remember the citation, but
that is nice. 90 Supreme Court, it is there. Only thing, my lord, here in Premnath Bali's case, my lord, is co-level. In paragraph 18, this has been stated.
Premnath Bali.
And paragraph 28, man. Keeping these factors in mind, we are of the considered opinion that every employer, whether state or private, must make sincere endeavor to conclude the departmental inquiry proceeding once initiated against the delinquent employee within the time by giving priority to such proceeding, and as far as possible, it should be concluded in 6 months as an outcome. Mani Singh, today I am not having to put it there. In the judgment under a judgment form. Yes, man. Judgment followed by Lord Mani Singh. Judgment followed. I can produce by tomorrow itself. I can produce. Yes. Another judgment is there, that is followed of 2018 Supreme. 1998 Supreme Court. This is 2015. Yes. Mani Singh's judgment tomorrow, I said. Yes. Yes, but that is the one still now it holds good. This is still prevailing defeat. Reference 2015-16 এসেছে।
the learned counsel for the mention.
Written by concept. I see the concept.
No, sir, you ask someone to mention.
Reference to child.